It's changed advocate on record.
My lord, probably the
Appellate side mentioning.
Earlier side non-commercial new application item number 1.
This is the application for recalling order dated May
What, restoration?
restoration, my lord.
Say that, restoration, recalling order dated such and such.
Sorry, my lord. Restoration 13 to May 13 is the default. I could not reach before, my lord.
2017 appeal.
My lord.
What remains in the appeal? Do you know what the appeal is about? You have no idea. What kind of order has been challenged in the appeal?
The order, my lord, we with the company under voluntary liquidation, we settle our dues to the respondent, and their respondent agreed with the amount settled with them. That is, they filed the suit, and in that
Appeal
suit,
from decree.
my lord. No, appeal from order, my lord. From decree.
Anyway, this appeal is ready for hearing otherwise.
Ready for hearing, my lord. There is nothing to oppose in the restoration. Lordship will keep the appeal on
Next week.
Yes, my lord, next week. The respondent plaintiff is 85 years old. My lord. It's been, and the money is lying, my lord, deposited.
This is an application for restoration of APO 339 of 2017, which was dismissed for default on May 13, 2025. Stop. Paragraph. Having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned counsel for the appellant. On the day, the appeal was dismissed for default. Paragraph. Accordingly, the order dated May 13, 2025, is recalled. Stop. APO 339 of 2017 is restored to its original file and number. Paragraph GA whatever 2 of 2023 is disposed of. Paragraph let the appeal be listed under the appropriate heading on Wednesday, next Wednesday, তারিখটা দিয়ে দাও। আজকে কত তারিখ? কিছুই মনে থাকে না। 2nd July.
Kindly fix next week, my lord. Next Wednesday week, my lord.
Wednesday week.
My lord.
9 July. No further time.
My lord.
Your bank is in liquidation.
My lord. Bank is under members voluntary liquidation.
And all my investments are gone.
Persis Kambata is Srimati Persis Kambata.
Yes, Srimati. Srimati versus Kambata. Grateful.
Not the actress.
No. Grateful.
Item number 2.
Lordship, this is my restoration application, your lordship
Wow.
mentioned yesterday.
Restoration. Have you served? You're appearing, Mr. Banerjee?
Yes, ma'am.
You're appearing but not opposing.
Opposing, ma'am.
Opposing?
Restoration.
Why?
But this application, please don't be so surprised. This application has been filed. This matter is for restoration or recalling of a decree after close to 14 years. So it's the
Recalling of a decree.
of a ex parte decree for in an undefended suit. There's a recalling application of an ex parte decree
No, this is recalling application of a dismissal order.
That's the main matter. So that gets dismissed for default after 2 or 3 times that they don't appear. The conduct has been appalling in this case. I never stand in the way for something like this. This, Your Lordship, will allow me to file an affidavit. Possibly it's out of time also. The restoration application. I'll just indicate. This was
21st April,
yes, 21st April 2025.
20th May. All right.
And 23rd May it has been filed.
20th May.
Oh, the case status shows 23rd May.
Affirmed on 20th.
Yes.
Yes,
So 20th.
Filed after 30 days.
After 30 days.
There is a delay.
Your Lordship, the condition of the appellant was very bad. She was in mental asylum, Your Lordship.
Long
Your Lordship, may,
Law will not change, madam.
Your Lordship may kindly heard the matter, Your Lordship, and the matter.
The law will not change. Law of limitation will not change for that.
Yes, Your Lordship.
Will change. Not change. Change or not change, decide. Not change. Then
Your Lordship, we could substantiate it before your my lord, when Your Lordship would hear the main application, Your Lordship.
we'll condone the delay on oral prayer, file an affidavit. Or file an affidavit to the restoration.
Lordship, I am appearing on behalf of the respondent number 2. I have not yet been served with the application, Your Lordship.
Serve in course of the day.
My instruction is that we have served, Your Lordship, but
Where is your affidavit of service?
I am submitting upon instructions that I have not received.
Your Lordship, we will serve, Your Lordship. I could not, actually my advocate on record is not here, Your Lordship, may kindly, Your Lordship.
Why do you do this? You come half prepared. You don't even know if service has been.
Your Lordship.
We will direct service in course of the day. We'll give direction for exchange of affidavits. This is an application for restoration of APO 17 of 2024, which was dismissed for default on April 21, 2025, paragraph. Their application for recalling of a decree was dismissed by the learned single judge.
Yes, Your
Yes.
That had been taken out 14 years after the decree.
14 years after
Lordship.
this.
Against that dismissal, they have come up.
They have come up and appeal. Here also, before Your Lordship, they don't appear. Not on one, but multiple occasions.
No, on six occasions we have appeared.
Learned advocates for the respondents strongly oppose this application. Stop. This is unusual as a restoration application is normally not opposed. Stop. However, is normally not opposed. However, learned advocates for the respondents point out that the conduct of the appellant has been far from happy. Stop. The appellant applied before the learned single judge for recall of an ex parte decree. An ex parte decree after 14 years.
After 10 years.
After
Sorry,
My
ex
instruction
parte
is 7
decree.
years.
After 12 years.
Ex parte decree, 10 years after the decree was passed. 10 years. 12 years. 12 years after the decree was passed. Stop. That application was dismissed by the learned single judge. Stop. Hence this appeal. Stop. Paragraph. Even in this appeal, on repeated dates, the appellant failed to appear when the matter was called on. Stop. Therefore, the respondents pray for leave to file an affidavit in opposition and coroner, leave to file affidavit in opposition. Paragraph, let affidavit in opposition be filed within 2 weeks from date. Stop. Reply thereto, if any, be filed within a week thereafter.
Your Lordship.
Paragraph,
Your Lordship, kindly 2 weeks, Your Lordship.
2 weeks. 2 weeks. 2 months. No. 2 weeks thereafter. List the matter 4 weeks hence. Date the other. Under the appropriate heading. Under the same heading. Same heading.
Your Lordship, we were also enjoying an order
Oh.
of stay by Justice Honorable Justice I.P. Mukherjee and Justice Vishwarup Chaudhary.
No, the list will
Nothing.
have to be restored for that.
Nothing. Let service of this application be effected on the respondent number 2 or his learned advocate on record if that has not yet been done.
One thing, great. Your lordship is condoning the delay of 2 days on an oral prayer. That will have to go down. Otherwise, my lord.
Let us condone the delay.
Yes, yes, that is okay.
প্রথমে একদম করে দাও, there is a delay of 2 days in presenting this restoration application. Stop. Having heard learned advocate for the applicant and on her oral prayer, comma, we condone the delay. তারপরে যেটা বলেছি।
এটা তোমার বলার কথা ছিল।
This is, you should share your fees with Mr. Banerjee.
Item number 3. Item number 3, I'm appearing for respondent number 6. I'm about to make a prayer. It might seem I'm coming from a misplaced sense of temerity over here. But also I'm praying for an adjournment of at least a month because the instructing client, she's undergone a surgery.
Who's instructing client?
Respondent number 6, she's undergone a surgery just yesterday in Bombay. It'll take her some time to come back and then instruct us adequately.
Yes, Mr. Chakraborty, you know the rule in this court. Second call, DD.
Then I will not stand.
We will adjourn. We will adjourn. Let us see.
Item number 4.
Next.
Item number
4,
5.
4,
My lord, I am for the respondent.
4 appellant.
That trust.
You are for the appellant. All the parties are here.
Yes, yes.
Appellant is the trust and respondent is.
Mr. Ghosh will take it up in the second call. Just let us
As in-
immediately.
As in.
Sure, new application to একবার দেখে দাও।
Item number 5. Item number 6.
5 appellant is there.
Number 6, lordship.
1 second. 5 appellant is
I'm for 5, my lord.
appellant.
The appellant, my lord, what has happened, my lord, in this matter, I'm led by Mr. Joyanta Kumar Mitro. And this matter is in context of a will of a person. If your lordship sees the name,
Oh,
he is very inclined to appear in the matter and do it. So, my lord, if your lordship kindly takes it up next week.
what has happened? What has the
I'll
learned
tell you,
single judge
Lordship,
done?
probate no, not contested. Probate application was preferred by the executor, came up before the learned single judge for hearing. My lord, my senior is here, my lord.
Well, this is an interesting application, my lord. So far as I recall, when my matter was called on,
Memo of appeal to দাও তো। Yes.
Yes. my lord, along with my matter, about 14 counsel were present.
Must be. I can
And my
see.
lord, no, 14 counsel in 14 different matters.
Oh,
So this particular matter is of such importance in the sense that a lot will depend upon the judgment of your lordship on this in respect of the other application. In fact, my lord, I would respectfully submit to your lordship that those persons should be given notice. I remember, my lord, a number of counsel were present, but unfortunately what happened was this: after my argument was over, none else was heard about it. And my lord, the judgment which was delivered is, my lord, your lordship kindly sees kindly see the order. My lord, all these persons were there, along with other persons also. And this judgment has been delivered. It's a longish judgment, but most of the judgments we have not cited. So this will require some amount of consideration with regard to jurisdiction of this honorable court. And my lord, if your lordship kindly see the Succession Act, I shall just indicate to your lordship the point involved. Kindly come to section 283.
এই ইয়ে দাও না আছে, ইন্ডিয়ান সাকসেশন অ্যাক্ট আছে।
Section 283.
রিজিনাল সাইড কোর্ট বইগুলো থাকে না, এগুলো অত্যন্ত বিরক্তিকর।
So may I hand up to your lordship, my lord, my copy? আমাকে একটা copy দাও। Lordship kindly takes section 283 of this. আমার কপিটা দিন যাচ্ছে আপনি। Well, may I please sit before lordship? in all cases, the district judge or the district delegate may, if he thinks proper, examine the petitioner in person upon oath. This is powers of the district judge. Then B, require further evidence of the due execution of the will or the right of the petitioner to the letters of administration, as the case may be. Then 3C, this is the important one. Issue citations calling upon all persons claiming to have any interest in the estate of the deceased to come and see the proceedings before the grant of probate of the letters of administration. Now, after C, kindly will not come to, I do not want to trouble your lordship with subsection 2. Kindly come to subsection 3, where any portion of the assets, this is the bone of contention, where any portion of the assets has been stated by the petitioner to be situated within the jurisdiction of a district judge in another state, the district judge issuing the same shall cause, note the words, a copy of the citation to be sent to such other district judge who shall publish the same in the same manner as if it were a citation issued by himself, and shall certify such publication to the district judge who issued the. Now, my lord, the issue is very simple. In the application which I have moved with regard to this particular will, no citation was required to be issued, because, my lord, the legatees have consented. In terms of, my lord, the High Court rules, our rules, my lord, no citation is required to be issued if, my lord, all the legatees consent. So, my lord, here the widow and the two sons, my lord, they have all consented, signature was there. So my short point, very short point was there, that kindly see subsection 3, a copy of the, you kindly see where any portion of the assets have been stated in the petitioner to be to situate within the jurisdiction of a district judge in another state, the district judge issuing the same shall cause a copy of the citation to be sent. Now, my lord, what happened was this, in this particular case, Mr. Sen had a flat in Delhi. So the question was whether a citation is required to be issued in Delhi. My submission was this, that a copy of the citation is to be issued, to be sent to the other district judge, provided a citation is required. If no citation is required, then no copy need to be sent. This was my short point, but this point had not been considered, my lord.
Which is the rule that says that citation is not?
Yes, yes, of course. My lord, kindly see our High Court rules, my lord, Testamentary and Intestate Jurisdiction, Chapter 35. Chapter 35, Rule 9. Citation to the rightful parties. Now, kindly come, my lord, first to the Rule 4. Application for probate or letters of administration or a certificate. Every application for probate or letters of administration with a will or without the will annexed shall be accompanied by a certificate of the registrar, then copy of the affidavit. This is a usual procedure. Then, my lord, 4A, 4B, affidavit of valuation, postponement of payment. My lord, the procedural rules have been laid down. Payment of postponed without proof of identity, administration of the creditor. Then, my lord, kindly come to 9. On an application for letters of administration, unless otherwise ordered, a citation shall issue to all persons having a right to take the grant prior or equal to that of the applicant, unless such persons have signified their consent to the application. In our case, my lord, on the body of the application, the consent was recorded. So, my lord, no citation was required to be issued. So, I submitted to my lord, I said that's a simple point. Subsection 3 says a copy of the citation to be sent. If the original citation is not issued, then how can a copy be sent? But that point has not, there's a lot of things have been discussed. I personally feel, my lord,
Yes.
that this is this judgment is of seminal importance, because when your lordship, my lord, I placed the earlier judgments, my lord, there had been some amount of discrepancy between the judgments, and there was one Supreme Court judgment which was in my favor, which was cited. My lord, that particular judgment, my lord, the learned judge has dealt with in a particular. I thought that perhaps.
So, what do you suggest, Mr. Mitra? Notice should be issued to the.
I would suggest, my lord, that kindly fix a date for hearing a fortnight or so after, In the meantime, and I shall issue my lord notice or my lord inform my lord all the parties who were there present in court in that day, on that day, so that my lord, whatever my lord submission is to be made, either in my favor or against me.
Those parties' appeals are not before us.
My lord, I do not know. Some of them had come to me and said that they have preferred appeal, but I do not know whether the appeals are there on the list. I don't think that the appeals are on the list.
No, possibly not. There
No.
is no.
My appeal is only on the list.
I mean, they can come and listen to you, watch the proceedings, but they will have no right of audience.
No. Unless, of course, they are
Yes, unless they have.
amicus by your lordship.
Yes. Very well. Esho.
Yes, sorry.
Appeal is directed.
Well,
So has the learned judge dismissed your application?
17 July.
Mr. Mitro?
My lord?
Has the learned judge dismissed your application?
No, my lord, this order kindly see, my lord, what he has said, what his learned judge has said is, kindly come to the last paragraph. Paragraph 22. That the petitioner is directed to comply with the requirement of section 283(3) of the Indian Succession Act. No, my lord, I do not know how to comply with it. But citation, my lord, a copy, I know.
Very well. We'll decide that. We'll decide that.
Your lordship will please do.
This appeal is directed against a judgment and order dated January 16, 2025. Stop. The appellant is the executor. Mr. Ghosh is the executor.
Mr. Ghosh is the executor.
Sole executor.
The sole executor.
The appellant, is the executor of what is said to be the last will and testament of late Probate Chandra Sen, who passed away
on 2nd May 2022. 2020.
On May 2,
2020. 2020. It's 5 years
during COVID, I remember.
Yes.
May 2, 2020. Stop. The appellant had applied for probate of the said will before the learned single judge by filing PLA 115 of 2023. Stop. All the beneficiaries under the will who are the only legal heirs of the deceased signified their consent on the petition. Stop. However, noticing that the deceased owned a flat in New Delhi, the learned single judge, referring to section 283(3) of the Indian Succession Act, 1925, এটা কি শুধু Succession Act বলে না Indian Succession? This is the Indian Succession Act or the Succession Act?
Indian Succession.
This book says only the Succession Act. Very peculiar. Yes. 283(3) of the Indian Succession Act, 1925, directed the appellant to comply with the provisions thereof. Stop. Section 283(3) reads as follows. বলে এখান থেকে just এইটুকু দিয়ে দেবে। এই page 99 এই বইটার। আমি মার্ক করে দিচ্ছি। Paragraph. Mr. Joyanta Kumar Mitro, learned senior counsel appearing for the appellant, says that the aforesaid section would have no manner of application in the instant case. Stop. Under Rule 9 under chapter 35 to Roman 35. Rule 9 of the original side rules of this court, comma, no citation needs to be issued in this case
Since all the legatees have consented.
since all the legatees have consented, legatees have consented to the grant of probate in respect of the concerned will.
Lordship.
Stop. Paragraph, we need to hear out the appeal. Stop. As suggested by Mr. Mitro, comma, let this, have you filed a stay application or something?
We have filed a stay application, but
All papers are before us.
all papers
There's
are
nothing excepting the will and the PLA
and the decisions. A
decisions.
lot of a number of Calcutta decisions have been, and my lord, two Supreme Court judgments, my lord, one Supreme Court judgment, the learned judge has been pleased to hold that this, I will not follow this. The Supreme Court judgment.
2018.
I will not.
You know, yes. If your lordship, my lord, kindly come to
Paragraph 19.
paragraph 19 at page 107. Well, paragraph 19 starts at page 106. The two judgments, 208, one Supreme Court cases, Bashanti Devi. This went from Calcutta. And well, Lynette Johnson, 2018, one Supreme Court cases, 271. Kindly come to page 107. I am unable to accept the ratio laid down in Lynette Fernandez. Well, about 8 lines from the top. At the revocation stage, as at that revocation stage, it may be on consideration of the facts, etc. Well, we'll have to consider all this.
Yes, we'll have to. Kivullam. Let this matter be listed again 2 weeks hence, data diya under the
Well, may I suggest, well, Learned Julia will not be here on the 17th July.
2 weeks likhona ota on July 17, 2025, under the heading specially fixed matter. Kaushik. Specially fixed matter 17 July ki bar.
I think Wednesday.
Thursday.
Then
Mark
6 in July. On Wednesday, perhaps your lordship takes up these matters.
No, we can have it on Thursday. Mark 3:30 p.m. Thursday 3:30 is safe. Mark 3 because this will take a little time. We have to consider all
Yes,
the
yes.
cases.
Judgments will have to be placed with your lordship. 3:30 perhaps can be at 3 o'clock.
Very well.
Or 3:30 perhaps will be convenient for your lordship.
So
Whatever.
that we can attend to the other businesses. 3:15. 3:15.
Your lordship is very kind.
On that date, comma, let a compilation of the decisions on which the appellant wishes to rely be filed along with any other documents, relevant documents.
Well, I will, your lordship will kindly direct all relevant judgments because on which there are some judgments which had been, my lord, the learned judge has said-
Compilation of all relevant judgments.
all
brother.
relevant.
All relevant judgments. You are being assisted by Junior Mr. Ghosh.
Yes, sir. Yes, right.
Of relevant judgments on which get the
My lord, before your lordship takes up the next matter, I'm praying for unconditional apology first, my lord, from the determination of Honorable Chief Justice. On very urgent matter, my lord. I know it's not the time for mentioning, my lord.
No, if you know, then please don't mention, sir. Maintain some kind amount of discipline,
I'm praying
decorum.
unconditional apology, my lord.
What example would you set for your juniors?
I'm praying for unconditional apology for that, my lord.
Yes,
That's my determination.
wait. When we rise, whenever it is, mention.
Grateful, your lordship.
But let these and others follow the.
There is a fresh batch of appeals, man. Fresh appeals, man, had to be filed because the interim order. I'm sorry.
Item number 6.
But 6 to 10 are my appeals. These are fresh appeals pertaining to the Marshall House matter which your lordships have released. But these have to be filed because the interim order was extended. In view of the reference being pending before the larger bench, it was supposed to be listed.
Released. We had released these matters.
No, it's the previous appeals. Since these are
Same parties.
yes, absolutely.
So you have to release because
Yes,
Release
it was
count of justice right.
yes,
Yes.
it was supposed to be listed before the regular bench, but
Regular bench, how is Justice Chattopadhyay from Monday? So, my lord, it is submitted, my lord, kindly, my lord, keeps it on Monday when the regular bench comes, my lord. That difficulty is not there anymore. This is the specific order of release, your lordship.
Miss Banerjee, please understand that bunch has gone to another bench.
Those have become infructuous.
No, we don't know. Hey, release এগুলো. We don't know. 6, 7, 8, 9, 10 একটা বলে দিচ্ছি লেখো same হবে সব. We are not inclined to take up this matter on the personal ground of one of us. বলে সাহেবের নাম দিয়ে দেবে. Paragraph, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction.
Pass over matter item number 3.
Item number 3, I was appearing for respondent number 6. I'll just renew my prayer for an adjournment for order.
No, usual order. Usual, dismiss for default. Give your reference, appearance. But you know the practice. If today they mention before we have signed the order, it will be restored.
I bow down to your lordship. Anyway, this is a 1-year-old appeal. They've not
Yes, if they are not interested, yes.
Technical item number 4.
Yes, Mr. Ghosh.
Not in this.
Matilal Sil.
Material. Like that famous building in Central Avenue. Lord, in the last occasion, my adversary took a point of maintainability that this appeal is not maintainable against an order, judgment and order passed under Section 74 of the Indian Trust Act. Lord, he intended to cite 2 judgments. Lord, reference has been given to me. Lord, I have considered both the judgments. Now, my lord, in my respectful submission, none of the judgments has any application in this matter. At the outset, I submit. Because, my lord, it is an intra-court appeal under latest patent, clause 15 of the latest patent. My lord, only consideration before your lordship today would be on the preliminary point as to whether a judgment passed by a learned single judge of this honorable court is appealable before a division bench of the same court. Lord, your lordship knows, Lord, I don't think I need to cite any judgment.
Yes,
but
why should it not be? If it is a judgment, why should it not be appealable under clause 15?
Yes, Lord, there are several judgments. Only one judgment.
The argument what is recorded is that since the Trust Act has no provision for appeal,
yes,
that is irrelevant.
that is irrelevant. And in fact, Lord, I have considered that there is no express bar under the Indian Trust Act of preferring an appeal. And in any event, it's a latest patent appeal.
Yes, sir, you have taken the point of maintainability. You argue first. Let him argue.
Let him. First is, Milord, my learned friend Milord proceeds on the basis that it can be a latest patent appeal.
Memo of appeal to the.
Milord, I'll address that point first, Milord. Kindly takes, Milord, section 74(1).
Trust Act though. দেখো তোমাদের অবস্থা দেখো অরিজিনাল সাইট সাকসেশন অ্যাক্ট নেই ট্রাস্ট অ্যাক্ট নেই না ছিল বলে তো লাভ নেই
My lord, may I
Please,
hand
please,
over my
please, please. We are sorry, but what to do?
lord, kindly ignore the marking, my lord.
Very well, yes.
If your lordship sees, my lord, section 74, it is an appointment by the court. Now, when, my lord, in case, my lord, section 73 fails. Now, my lord, 74 starts with appointment of new trustee on death, etc. Lord, this
74.
74 of the Indian Trust Act.
Appointment of?
Appointment of new trustee on death.
That is the caption.
That is the caption.
No, then this is the old book we are
I'm
reading. out.
sorry, my lord, appointment by court.
Yes,
Appointment by court.
Yes.
73 is appointment of new trustee
yes,
on death, etc.
yes,
74 is appointment by court.
yes.
Whenever any such vacancy or disqualification occurs and it is found impracticable to appoint a new trustee under section 73, the beneficiary may, without instituting a suit, apply by petition to a principal civil court of original jurisdiction for the appointment of a trustee or a new trustee, and the court may appoint a trustee or a new trustee accordingly. Now, kindly see, my lord, rule for selecting new trustee. In appointing new trustee, the court shall have regard A to the wishes of the author of the trust as expressed in or to be inferred from the instrument of trust. B to the wishes of the person, if any, empowered to appoint new trustee. C is to the question whether the appointment will promote or impede the execution of the trust, and when there are more beneficiaries than one, to the interest of all such beneficiaries. Now, over here, my lord, this is an appointment under section 74 because 73 has failed. Now, my learned friend says, my lord,
You are a beneficiary under the
I am
trust?
a beneficiary under the will, my lord. Now, my lord, my learned friend says that it has to be a latest patent appeal. Now, my lord, Shah Khimji says, in order to be a latest patent appeal, my lord, any right has to be adjudicated by the court. Now, over here, in an application under 74, it's just an appointment of a new trustee. The existing trustees.
Your
no
right,
is
your
given.
right to be appointed as a trustee
My right to be appointed
has
as
been adjudicated in your favor.
my favor, it is adjudicated.
So the court has adjudicated a right which you claim
Yes.
to be appointed as trustee.
Yes.
Why should it not be a judgment?
But there is no right, Miller, decided for the trustees, Miller. In case, Miller, let us take, Miller, this situation. In case, Miller, I have been appointed as a trustee and they come up for my disqualification. I have been disqualified or I have not been disqualified. Then an appeal preferred, of course, Miller.
Mr. Ghoshal, let us, we are not with you on this point. Let us address the merits. Let us not spend time on this. Yes, on merits, what is your case?
So, my lord, I am not relying upon any judgment on latest
No,
patent.
no.
Lord, law is well set. But kindly take up the stay petition. Kindly look at the order. Your lordship on the last occasion, please to look at the
We have the order from the memorandum.
From the memorandum.
Yes, we have it.
My lord, only few paragraphs I shall show. Memo of my lord, two paragraphs of the judgment under appeal.
Mr. Ghoshal, we are hearing out the appeal.
Yes.
Although it's appearing as new application,
Yes.
all papers are before us.
All papers are.
All papers are before us. Then do this. Kindly file an informal paper book. Informal paper book. Next week we'll list the appeal.
Because all the papers are only the
Stay petition.
few affidavits filed before the learned single judge.
Correct.
And my lord, the memo of appeal and the stay petition. Nothing more.
So,
and my lord, we have prepared a chart, a colored chart for your lordship's convenience to show as to how the person nominated by the trust should get a chance for the current session. That only I shall include, which was there before the learned single judge. Single judge দেওয়া আছে, color chart দেওয়া আছে। 7 তারিখে তো হ্যাঁ আমিও তো থাকবো না।
We'll treat the stay petition as an informal paper book,
Grateful. Yes.
right? And come back then next Monday or Wednesday
Any day after 7th of July.
after 7th of July.
The Lordship knows Lord Jagannath.
Oh, you are going to the Lord. Very good. Do pray for us.
But I was trying to impress upon your lordship that I have some kind of urgency, but the reason cited by my learned friend, my lord, I cannot say anything. My lord.
This will be my 23rd year visit.
Consecutive.
From 2nd July to 7th July.
Sure. Asho, this appeal is directed against a judgment and order dated February 19, 2025, whereby the respondent's application under section 74 of the Indian Trusts Act, 1882, for being appointed as a trustee of the concerned trust, has been allowed by a learned judge of this court. Stop. Being aggrieved, the trustees have come up in appeal. Paragraph, we have to hear out the appeal. Stop. We are told that all papers that were available before the learned single judge have been annexed to the stay petition filed in this appeal. Stop. We propose to hear out the appeal treating the stay petition as an informal paper book, dispensing with all formalities. Stop. Since the sole respondent is represented, through learned counsel, notice of appeal is deemed to be waived. Paragraph, list the appeal and the connected application for hearing, under the appropriate heading on July 9.
Yes.
On the undertaking of Mr. Ghosh, learned senior counsel, that he will pray to Lord Jagannath for all of us.
Sir, duty incumbent upon me. The duty incumbent upon both
9 July.
Myself and Mr. Pradeep Dotto, senior advocate, we are in a team, and this is the 23rd consecutive years. We shall miss.
That is very nice. That's the Lord's blessings on you.
Not the only thing, Lord, I have prepared a chart, colored chart for your lordship.
Give him a copy right now.
I have we shall read it.
Genealogical table.
Genealogical table. I'm extremely grateful.
My lord, may I take back my...
Yes.
Part number 11.
May it please, my lord. On the appeal for the state, this appeal is from a decree of 1996. 3rd of June 1996, passed by Justice Babulal Jain. No reasons have been given, no proof, no fact, no evidence was taken.
Other side.
On the other side, we have tried to serve. They are not being traced also. We have given that, and we have deposited the money. I'll tell my lord very briefly the facts. Maybe there's one small point I'll have to come back to, my lord. I'll just quickly, since this your lordships hear it, I won't take more than 5-10 minutes. My lord, the Vikas Trading, the plaintiff was receiving a consignment of turmeric bulbs in the station. Thereafter, those goods were seized. He had filed a writ petition. The writ petition was dismissed initially. Seized
by whom? Seized by whom?
Seized by the authorities, the railway authorities, the Union of India and the state of West Bengal were made parties.
Okay.
Thereafter, the appeal was preferred in the writ, and there an observation was made. I think Justice Anil Sen was there at that time. And the observation was made that this is completely done at the behest of these two officers, and they should be personally sued. So the plaintiff went back and filed a suit against Union of India, State of West Bengal, and these two officers. And nobody except Union of India appears to have filed a written statement. We have not filed a written statement. No one filed. But ultimately, Justice Jain held, since the division bench has held that they should be sued, so I'm passing a decree against the state, and the state will pay the decree and will be entitled to recover it from their officers. So that was the order. But nowhere is there any evidence that the state acted in a malafide way. Justice Jain solely relied on this writ court order, which said obviously a suit had to be adjudicated.
First thing, Mr.
No
Ghosh,
reasons.
First thing.
Yes.
Was it an ex parte decree insofar as the state and its
Yes,
officers are concerned?
But I was just checking on that. I was taking instructions, but it appears from the decree that the Union of India filed a written statement.
Maybe, but Union of India is not before us.
It was ex parte against us.
Yes, so why should you not approach the learned single judge? Why
Because
should
he's
we
not
enter?
there.
This is normally what we do, Mr. Ghosh. Order 9, Rule 13 is there in the statute books. You chose to stay away from
No,
court.
the appeal was filed. We've put in the money.
Maybe.
Initially, a contempt had been filed that we hadn't complied with this. Then the
Maybe.
money has been secured, and the plaintiff, I'm told, is in South India.
Yes.
We've given even paper publications. He's not coming. He hasn't tried to execute the decree also.
But this is normally what we do, Mr. Ghosh.
Yes.
We don't, if
But
it's
here
an
the complete order, the decree has been passed, and in the judgment, your lordship will find, except for saying that the division bench has already found that there, with oblique motive and unholy and malafide proclivity, the respondents had acted, then they should be personally sued, and therefore.
Look, the plaintiffs have disappeared, it seems.
Yes.
Go back to the learned single judge, have the decree recalled, give sufficient explanation for your absence.
My appeal has been pending from 97.
Yes, that is obviously because your client was
No,
too much interested in the matter. It was listed at our instance.
Yes. That is a fact that it was, they haven't taken steps, but we had secured the money also. So it's not that if the plaintiff comes today, he can still get his money. The money is secure. But if the security remains and we go back to the trial court to have it heard out on merits.
Yes.
That is, but going back to Order 9, Rule 13 now will be a difficult problem.
Why? Because you have no explanation for your
First,
absence.
I have noticed, I'm sure that we'll not be able to find whether the writ of summons was served on us or not. All those things are there. My lord will see the order, page 70, it's a short order, 75 to 77.
What is the evidence that you have tried to serve? The
Yes.
appeal papers on the
The
decree holder.
paper publications were made. Affidavit of service has to be. The facts I've told my lord, I will take 5 minutes to show those facts. But what I wanted to show, what I thought would be interesting is some decisions on vicarious liability.
That's very nice.
So, but those are, that's why I said that I have one point that I need to come back on that. I found 1 or 2 decisions, but besides vicarious liability.
You want to come back on that?
Yes, on that. Then
Come
that's
back.
the only interesting thing about the case. But if my lord sees the order,
That
there's
is
no reason.
Basically a tortious concept, isn't it?
Yes, if it is a tort, if it's an illegal, if it's a crime, if it's been held that they are doing something outside the scope of their duties, as has been observed by the division bench, if we go by that. But of course, the observations and writ courts are made. They have to come and prove it. No evidence is tendered.
Come back with all your authorities and
the affidavit of service.
Evidence of service in whatever form.
I'll come
Paper book.
Next Wednesday.
Where's in the paper book? Where is the impugned judgment order?
On page 75. It's all typed copies. 75 to 77.
This came as undefended suit, no?
Your Lordship will find from reading the thing that was also the Union of India has filed a written statement. It doesn't mention whether we have or not. And no decree is passed against the Union of India. Just a one-page order.
This appeal is directed against. This appeal is directed against the. Chuni. Only thing to service today. Are you prepared with the service today? We can set aside this judgment here and now. There's nothing.
There's no reason.
No adjudication.
No. No reasons, no proof.
No, but then you have to show us surveys.
At 2 o'clock, can I come back? He'll come with the service.
Come at 2 o'clock. Likho na kichu.
Great.
Item number 12.
Appearing for the appellant. By order dated 11 June 2025, I was
For retrial. Yes.
By the last order, I was directed to serve upon the respondents. Upon the advocate on record for the respondents. Now, the advocate on record, as we knew, was Mr. R.L. Dutt. Now, they have refused service. Now, Lordship will direct that we serve upon the respondents number 10 and 12.
They are the ones who haven't been served.
9 and 12.
They are the only ones who haven't been
You
served.
are contesting, Lordship. In fact, I have filed an application under Order 41, Rule 27. And it is these two respondents who have responded by filing an affidavit in opposition. I have also filed my affidavit in reply to that. My only prayer, Lordship, my application may be allowed because pursuant to directions of this Honorable Court by the Honorable Division Bench, that all the papers used in the appeal may be filed in the paper books. Now, these papers which I intend to bring on record are documents which are matters of record because these are orders and pleadings. Those were relied upon during the trial, but they were not part of the pleadings filed before the trial court. Now, my only prayer, let the application may be allowed.
Miss Addo, we always hear out that application under Order 41, Rule 27, along with the appeal.
Yes.
So we'll take it up together. You file whatever you want to file, but immediately you serve on the 9 and 12 on the response.
Upon the parties, Lordship, I shall file.
Learned advocate for the appellant says that in terms of our order dated, in terms of a coordinate benches order dated June 11, 2025, the appellant sought to effect service on the learned advocate on record for the respondent numbers 9 and 12.
Yes, Lordship.
Same advocate on record.
Yes, Lordship.
9 and 12. But he or she refused service. Lady, he or she, who? Advocate?
Lordship, the advocate is solicitors and advocates Rajendra Lal Dutt and company.
But the learned advocates, but the firm refused to accept service. Paragraph, let service be effected directly on the respondent numbers 9 and 12 and affidavit of service be filed in court on the next date.
Lordship will give me a fortnight's time.
Paragraph as requested by learned advocate for the appellant, comma, list this matter after a fortnight. Bracketed date ta diye do.
Item 13 and 14.
The main appeal, my lord, perhaps, my lord, lordship was hearing it with in the other bench, my lord, with
Oh.
Justice Chattopadhyay.
Monday.
No, my lord, only one thing, my lord, I have a GA. My lord, I want a formal stay of the execution proceedings because I have secured the entirety. My lord, even before the other bench, my lord, here they are taking adjournment and they are proceeding in execution.
No. I strongly oppose.
Let my learned
We did
friend
not even go there. I strongly oppose this, sir.
His junior was there.
Well, I don't want to go into it. I know exactly what submissions were made, but I have secured it. Well, formally, this application can be. Well, I'll just show your lordship 2 pages. GA1 can be taken up, my lord.
Mr. Gupta, we are about to dispose of the appeal. It's not expected that you will proceed with the.
Two. My lord, in fact,
Therefore, we will record your statement. We'll record your statement.
two things.
Yes.
What happened there? We did not go. We did not make any submission. They went. They filed an affidavit of asset. My junior was only present. Did not make any submission. They filed an affidavit of asset. No, we did not press for any order.
Very well. We will record that. That you will not press also.
Yes. But two things. My lord, A, that affidavit of assets is not in accordance with the.
That you
what is
tell
been
the
filed.
learned trial court.
Yes. Secondly, there is a stay application which was disposed of in this appeal.
Well, my learned
I'll
friend
show
is
that.
incorrectly instructed.
Kindly seize the first order.
Lord, let me move my application, my lord. Let me move my application.
Application disposed of.
Either one of us is
not to
correct.
secure.
Yes, kindly see
Not
page
to
9.
secure, disposed of. Kindly seize this order.
Did you file before this? Did your client file any stay application?
There was no prayer for stay. Lordship will see that. My learned friend is incorrectly instructed.
Where is that application?
Lord, page 9, my lord, Lordship will see. It was a condonation of delay that was allowed.
And this was the observation in paragraph.
And will kindly see para 2. The pendency of appeal shall not operate as stay of operation of the decree
Because
or
I
order
did not
under
ask for a
challenge
stay.
because I had not asked for a stay.
Kindly seize para 9, GA1 disposed of.
That
Yes.
was for a condonation prayer.
That was the condonation application.
Where is that application? You have a copy of that application.
Shall not
We want to have a look at the prayers.
My lord, I shall.
If the prayer was there, then it would be deemed to have been refused.
No, my lord. Prayer was not there. And in any event, today, my lord, it's a fresh application because now I have secured it in terms of the order passed by the learned judge.
Very well. Even then, come back on Monday. That bench was considering this. Come back with the previous application.
Very well. Well, Monday the execution is there.
Tuesday.
Mr. Gupta is assuring us
Did not.
That they will not
Did
proceed.
not. We-
After that, if they
Very well, my lord, very well.
I did not even appear that day. I didn't even go. I said that since we are proceeding in the appeal, I'll not.
since these matters were substantially heard by another bench, another division bench, which is likely to be available from Monday date dao, comma, let these matters stand adjourned and be listed again on Monday date diye do.
This is the last day's order in execution.
This is the pursuant to last
day's order.
Just appeared. That's it. Ritik Chaudhary had appeared.
Just ensure it's not heard.
Lordship need not indicate.
Come back on Monday. What is the amount you have secured?
3.18 crores.
3.18 crores.
It is possibly not secured yet.
It's lying in my bank account.
Lying where? Lying?
It's a current account. I do not know whether
No, that is not enough.
that
Mr.
is.
Dutta.
I do not know that.
No, my lord, this is
The bank certificate.
bank
In terms of-
certificate. It is lying there. Lordship will, my lord, I'll
Attach
keep
for
it
this.
there. Attach this money.
Attach this.
I'm
If,
saying that.
if necessary on Monday, we'll do.
Yes.
Yes. Grateful.
Because I have completed my argument. Lordship would recall in this matter, I had completed.
Yes,
it.
we wanted to hear you why this is that 9 crore, 10 crore, whatever it
No,
is.
my lord, this is the other one. Well, this is that, my lord, First,
Juice Gully,
Juice
Oh,
Gully mean
Juice
profit
Gully,
will
Juice
be, I
Gully.
relied on a judgment of
Yes,
Justice Sikri.
Yes, yes, yes.
Proportionately, it will be.
I am getting confused.
And what is falling from your lordship, my lord, I have got it, my lord, I'll satisfy.
Yes.
Mr. Jishnu Chaudhary has,
Yes, yes, yes.
he has relied on the other deeds and has said the average will be 10 crore and all.
Yes,
That is the only point I'll answer it. In fact, it inures to my benefit.
But could it get some precedence on Monday? My lord? That
Well,
is what-
can this
only-
be on Wednesday? Monday and Tuesday, I may be in some difficulty.
Wednesday, Tariq to the
I appear on behalf of the respondent.
Item number 15.
I'm for the appellant, but
other bench.
Monday,
Monday. ওই সেম অর্ডার করে যেটা বলেছিলাম সিন্স দিস ম্যাটার ওয়াজ সাবস্ট্যান্সিয়ালি হার্ড বুঝতে পারছো কোনটায় করেছিলাম ওটা হ্যাঁ আগের ম্যাচ হ্যাঁ ওইটাই সেম অর্ডার আজ মানডে যা তারিখ হবে এটা খালি সিন্স দিস ম্যাটার হবে আর একটা দিস ম্যাটার্স ছিল
Item number 16.
petitioner, my lord, it has also been, my lord,
That
hard
matter
at
where the matter pertaining to interest, Lordship was hearing that.
সেম করো মানডে
Kindly fix this up Wednesday, subject to my learned friend.
Ready on Monday, Wednesday, whenever your lordship fixes.
তাহলে ওই লিস্টিংটা ওয়েডনেসডে করো
I'm deep.
Item number 17.
That is leading you. Lordship will remember that.
Sorry, who is leading you?
Mr. Suman Dutt, senior advocate.
Yes.
Let us begin.
17 and 19 are connected.
Yes.
শুরু করবি না
Lordship, may I? Suman Dutt. No.
Up to you.
If my senior is coming, then only I'll commence, Lordship. Otherwise, I do not intend to waste judicial time.
Then when will you tell me whether a senior is coming or not?
Start one.
May I start, Lordship, at the time?
And then after 10 minutes, don't say
Very well. Lordship, may it be passed over, Lordship.
pass over.
Passed over. I'm grateful.
Item number 18.
17, 19.
17 and 19.
17, 19, huh?
My lord, 18 also possibly has to, my lord, stand over till Wednesday, my lord. This is that section 37 appeal, Mr. Chaudhary, my lord, was arguing before the other bench. Service tax 8% extra. Whether it's, my lord, since the pre-contract documents and post-contract documents contain that clause, whether that would be, my lord, whether the learned judge was right in reinterpreting the terms of the contract.
Which করে দাও next Wednesday, ওই same order যেটা. Since this matter was substantially heard.
Difficult.
Where's your brother these days?
He's in Delhi since
In Delhi.
2010.
Oh, since 2010, he's in Delhi. Let me see.
He comes down and does matter when he's not. No.
That was precise.
Item number 20.
20, I'm for the respondent.
Lordship, I have appellant state, Lordship. Mr. The advocate, learned advocate general is leading me, Lordship. Sir,
Tell us more. What do you want?
Lordship, may it be passed over.
Pass over?
This is that matter where
I was the arbitrator.
that has been released.
That has been released.
This is a
This is the
consent.
sixth
Consent.
adjournment. They will be
Sixth adjournment.
Lordship, I'm not seeking adjournment. Mrs.
Yes,
Banerjee is there leading me. She's here. She can. I also have a leader, Mr. Dotto, the AG Millard is leading me.
This is, my lord, my appeal.
Passed over, passed over.
Purported consent. I'm ready to start, but pass over.
Item number 21.
My appeal. Arising out of the reject an application which was filed under Order 12, Rule 6, that's been dismissed. We have preferred an appeal challenging that order.
Lordship, I am appearing on behalf of the respondent number 13 and 14. I am led by Mr. Rishabh Banerjee and Arpita Shah, my lord. I believe Mr. Banerjee will appear virtually, your lordship.
He will appear virtually. Where is he? Is he not in Calcutta?
He is traveling to Delhi for an urgent matter.
We don't know whether we are going to hear him virtually or not. Connectivity is an issue, Mr. Chaudhary. We can't hear half the things.
Then, my lord, lordship keeps it because I am ready, my lord. না বেঞ্চটা তো রেগুলার না সেটা তো করে দিতে পারি
Your lordship.
করে দেবো আর কি হয়ে যাবে But I understand, my lord, they are saying that he is likely some.
Your lordship, Mrs. Saha, she is on the way. She is about to reach, your lordship. My learned senior friend can stand.
He is about to
Reach, your lordship, reach the court.
The learned
Mrs.
junior
Saha.
is there, my lord. So, my lord.
Are they in a position to do the matter today? This is what we ask. Physically.
My lord, they are.
Your lordship, let my learned senior friend stand.
Yes. Do not seek an adjournment after Mr. Chaudhary finishes.
Lordship.
My lord, the appeal arises out of, my lord, a dismissal of a application seeking judgment upon admission. Now, my lord, judgment upon admission in an eviction suit. That lordship will kindly first take, my lord, page 118. In fact, my lord, I first show your lordship the plaint. My lord, the plaint starts at page 19. Volume 1. Plaint starts at page 19. Lord, I'll tell your lordship, my lord, the main lessee, my lord, this is in respect of a lease which had been.
One second. This concerns the Rajan Mullik trust.
The original owners, my lord, this is a sublease. We are fighting for a sublease. The original owners are the Malliks. But Malliks have been made parties here only because, my lord, in the interest of justice. No relief is being sought for against the Malliks.
Yes.
Well, the main lessee of the property was defendant number 1. Now, under defendant number 1, there were 4 sublessees who are the defendant numbers 2 to 5. Now, the sublessees further inducted sublessees. And my lord, for the moment, we are concerned with only defendant numbers 13 and 14. The judgment upon admission application was, my lord, against defendant numbers 13 and 14. So, my lord, if lordship comes to the cause title first, in the plaint, that Orient Beverages is defendant number 1, who was the lessees. The defendant numbers 2 to 5 at page 20, lordship will find the Schroffs, the Schroff family, who were the sublessees. And my lord, initially from defendants 11 to 18, they were all claiming their rights, and it's an admitted position. All of them are claiming their rights through defendant numbers 2 to 5. But we are concerned here with only defendant numbers 13 and 14. I just show your lordship the necessary averment in the plaint. But kindly straight away come to running page 36, which is internal page 18 of the plaint.
No, you have claimed against 1 to 5 and 11 to 18.
Yes, well, leaving the Maliks aside, Maliks have been left out.
Yes.
Maliks have been made a party because the as most part of Calcutta,
Yes.
Running page 36, internal page 18. In the facts stated herein above, plaintiff is entitled to claim a decree for khas possession of suit property as against defendant number 1 and all other defendants claiming to be sublessees under defendant number 1 and the defendant numbers 11 to 18. The said defendants have no right to remain in possession in the suit property inasmuch as they were holding the demise premises under subleases granted to them by the defendant number 1. Upon the expiry of the said lease, the defendant numbers 2 to 5 have ceased to have any right to continue in possession or occupation or to use and enjoy any part of the suit premises. The plaintiff is entitled to a claim decree of vacant possession. Now, 3 facts are admitted. Number 1, that the lease had expired. The lease period had expired of the main lease of defendant number 1.
Who are you? Owners are the Maliks.
Correct. Well, when I say lease period had expired means I am the head lessor. I am coming to that.
You are a lessee under the Maliks.
For the subsequent period.
Under the Maliks.
Now, Millard, the lease period had expired. The learned judge has refused the judgment upon admission, primarily on the ground, Millard, out of the various defenses, one defense which, Millard, fell for consideration before the learned judge is fraud upon underlessees. That is one of the defense which has been taken. And Millard, that is one of the ground for which, Millard, the learned judge deemed it fit that it perhaps requires trial, not on the other issues. Because defendant number 1 has submitted before this court that the lease has expired and it doesn't have any claim. So, question is, it's a pure question of law. Can there be fraud upon underlessee when admittedly the main lease has expired? That is the pure question of law. Because, what is a fraud upon underlessee? There is a lease of 50 years. The lessee, inducts sublessees. I enter into a compromise with the lessee and I seek eviction of the sublessees. When the sublessees under the bona fide belief that I am entering into a 50-year lease or the residual lease period is 40 years, they are faced with eviction. That is what is classically called a fraud upon underlessee. Now, it's a pure question of law. Can at all this be a defense when, all of us are ad idem that the lease has expired? This is the only question of law that is relevant over here. Now, this is the plaint. The reliefs are at page 45. I just quickly show your lordship the reliefs. When we are concerned with relief B as against the defendant numbers 13 and 14. That is the only part. Now, why the judgment upon admission? That is what, I have to show your lordship. Kindly come to page 118. I first show the admission of defendant numbers 2 to 5 in pleadings filed before this court in interlocutory proceedings. 2 to 5. Because defendant numbers 2 to 5 are the main lessees, under whom defendant numbers 13 and 14 are claiming rights.
You said defendant number 1 is the main lessee.
defendant number 1 had given a lease to defendant numbers 2 to 5. Defendant numbers 2 to 5 had further sub-lease to various other people,
So-
including defendant numbers 13 and 14.
So there has to be an admission of defendant number 1 also.
Defendant number 1 has already surrendered. Surrendered in the sense has admitted that the lease has expired. I'll come to that. But I first show 2 to 5. Defendant numbers 2 to the affidavit starts at page 114, volume 1. One factual correction, my lord, so far as plaintiff and defendant number 1, there is already a terms of settlement where, my lord, they have admitted that the lease has expired and they are not claiming it. This is, my lord, plaintiff and defendant number 1. I'll show that. And it is in this background, my lord, fraud upon underlesses have been pleaded. Well, the affidavit starts at 114. Kindly come to page 116. Lordship will find, my lord, the defendant number 2 affirms the affidavit on behalf of himself and also for 3, 4, and 5. That is Rajendra Kumar Shroff for the entire Shroff family. Now, my lord, the relevant part with which we are concerned, kindly come to page 118. Before dealing with the statements, I submit the following facts. Now, my lord, under para 5, subpara 1, I place from that. And this is where, my lord, the admissions, according to me, my lord, it's a fit case where judgment upon admission should be passed. Because, my lord, 13 and 14 cannot have a better right than what 2 to 5 have. I state pursuant to a lease agreement entered into by and between the respondent numbers 2 to 5 and the respondent number 1 entered into on or about 18th August 1989, whereby the respondent numbers 2 to 5 have been described as sublessee and the respondent number 1 has been described as sublessor. The respondent numbers 2 to 5 have been given possession of the entire 10th floor of the said premises on inter alia the terms and conditions recorded therein. It was always represented by the respondent number 1 that by way of a registered deed of lease dated 29 September 1965, the original owners, that is the then trustees of the trust estate of the respondent number 6 to 9, had granted a lease of the said property to the respondent number 1 for a period of 50 years with a right to the respondent number 1 to construct new building at the said premises and let out or assign the same. So, my lord, two admissions are there. The original lease by the Malliks or the trustees was for 50 years from 1965. Well, admitted position that 50 years has lapsed. Well, the next admission. And being aware of this main lease of 50 years, they entered into a lease of 18th August 1989. Pursuant to the deed of lease dated 18th August 1989, the respondent numbers 2 to 5 have been in possession thereof and have been enjoying the premises by making payment of monthly rent as stipulated therein. On or about 10 September 2015, the answering respondents were approached by the petitioner and represented that pursuant to an order passed by the Honorable Court permitting the aforesaid trust of the respondent number 6 to 9 to execute a lease in favor of the petitioner, a deed of lease of 31st March 2001 was executed to take effect upon expiry of the lease of 29 September 1965. Accordingly, the petitioner sought for vacant possession and threatened the answering respondent to make over possession since respondent 2 to 5 no longer had any right to continue in possession upon expiry of the said lease dated 29 September 1965, that is on 30th September 2015. So, my lord, three facts are admitted. The head lease was for 50 years. The sublease was from 89, which expired on, my lord, 2015. And, my lord, they also admit that how we come into the picture. Because the lease is for the next period after the original lease expires. I am, my lord, I have been given the lease.
The lease was executed, lease did in your favor pursuant to a court order.
Yes.
Little unusual that that document was executed in 2001.
Yes, my lord,
Take
my lord,
effect.
my lord, the trust is, my lord, I'll indicate, my lord, the trust, what it does, and it is doing it, my lord. Moment a lease expires for the future period, my lord, they are executing the lease so that, my lord, they themselves don't have to take the trouble of undertaking eviction proceedings and fighting litigations. They are interested, the trust gets the money, the consideration, whatever it is in the lease, and my lord, this is
14 years prior to expiry of the lease. Anyway.
because, my lord, the main lessee was nowhere in the picture, my lord. It was tenants and subtenants and lessees or sublessees. So, my lord, they knew that it was a Herculean task. And, my lord, in fact, my lord, their foresight somewhat is seven six.
But they say they filed a suit. What happened to that suit?
But I'll come to that. My lord, in a suit, that suit is for declaration and injunction. My lord, they have an order of status quo. My lord, that order of status quo, and my lord, that would be my second argument because the learned judge has considered that. That cannot, my lord, defeat a suit, which is, my lord, the main suit is you can't be evicted without due process of law. This is the due process of law. So you first have to be successful in getting a declaration of tenancy, and status quo is your right is there, but it doesn't prevent that status, my lord. It's not a status quo order can't be interpreted that a due decree can't be executed against you. That is, my lord, my second point of attack. I'll come to that later. Now, my lord, kindly come to page 176, volume 2. I showed your lordship the pleading. Now I show your lordship the agreement under which, my lord, the defendant numbers 13 and 14 are claiming the rights. So 176. And this is the second admission. I showed the admission of defendants 2 to 5. Now I show the admission of defendant 13 itself because defendant 13 is a party to this document.
Give us 5 minutes,
Yes.
Mr. Chaudhary. What is he suggesting?
My lord, till recess, my lord, if lordships can release the other.
You'll keep us
My
occupied?
lord, both of us will definitely keep your lordship.
Released till recess.
My lord, I showed your lordship, my lord, the pleadings of defendant numbers 2 to 5.
Yes.
Where, my lord, two facts are admitted, that the head lease was of 50 years.
Yes.
The sublease was from 89, and my lord, both were expiring on 2015. So 2 to 5 admits the position that the parent lease of 50 years and the sublease both are expiring on 2015. Now, my lord, I show the document by which, my lord, defendant 13 was inducted. Kindly come to page 176, volume 2. And this is, my lord, what is relied by them. I'll come to the suit, my lord, later. I show your lordship the pleading. Well, this is the agreement, my lord, between defendant numbers 2 to 5 with defendant number 13.
Yes.
But kindly see the first recital. The lesser is the lessee till 2015 in respect of office space described in second schedule 50 Chaurangi Road, so and so.
Which is the building? This is not the Chatterjee International, no.
No, this. I understand it's the it's the second adjoining building of that Olpadwala Hall that is there of the Parsi.
Yes, Olpadwala.
Olpadwala Hall, that Parsi community hall that we have where
next to New Embassy.
It's the second adjoining building, not exactly the adjoining.
He would know New Embassy, definitely.
So, my lord, this is, my lord, and this is the document by which, my lord, defendant 13 is claiming their right.
Yes.
My lord, I want to show after the document, kindly see what is the written statement filed in this suit. What are the averments made by defendant 13? If lordships are pleased to take volume 5.
This lease, this is between Puja Shroff, etc. and
2 to 5, that is, my lord, the sublessors and the sub-sublessees.
Yes, and Siddharth Carriers. Siddharth Carriers is D 13. Who is D14?
D13 is, lordship will see at page 4, CTI Logistics, formerly Siddharth Carriers Private Limited.
Yes, correct.
And D14 is CTI Infrastructure Private Limited. It's their group. There is a similar agreement with D14 also. I'll give you a lordship the page. I'll just cover D13 first. Kindly now take the averment made, and this is in the written statement itself in this suit. It starts at 598. I would be showing Malad page 601, which is in volume 5. Volume 5, page 601.
Oh, this agreement was for 3 years.
That's the second, Malad. I am on the best possible case because, Malad, the defense really is not that they have a valid agreement. Tenant at sufferance and fraud on underlessee, whichever way lordship looks at it, in view of this admission, Malad, why should we go for trial? What will be achieved in the trial when these facts are admitted? And that is, Malad, that is the latest trend of the Supreme Court, Malad, so far as judgment upon admission is that whether there is any possibility of the defense to succeed, any possibility. I have to put my case that high. Now, my lord, whether I pass the test or not, it is for your lordships to decide.
Yes.
So, my lord, 598, the written statement starts. This is the written statement of defendant 13. But I show your lordship, my lord, from page 602, kindly come to internal page 5. But subparagraph B, this is paragraph 9B. The answering defendant is a subtenant in respect of the two office spaces measuring 492 square feet carpet area and so and so. But I need not trouble your lordship with the rest. Let kindly straight away come to, my lord, they refer to the owners Maliks, then they refer to the head lease, subpara D, that is the lease of 65 years. And then, my lord, kindly come to subpara F. The defendant numbers 2 to 5 thereafter inducted the answering defendant as sublessee in respect of the said tenancies as detailed herein before and put the answering defendant in possession thereof. At all material times till January 2016, the answering defendant paid and the defendant numbers 2 to 5 duly received rent in respect of the said tenancies and acknowledgement of the same issued money receipts. Then, my lord, how I apprehending eviction by the plaintiff, the defendant numbers 2 to 5 filed title suit number so and so before City Court at Calcutta, praying for delivery up and cancellation of the deed of lease dated 31st March 2001. The said suit is pending. My lord, this deed of cancellation they are seeking of my lease.
You were made a party there.
Yes. Now, my lord, whether, my lord, they at all have a locus or not. This is the first question. The second question is, assuming they have a locus, can this be at all a defense? I'll come to that. Because, my lord, this is, my lord, the sub-lessee. Because I can understand, my lord, this prayer will be a consequential relief if, my lord, they are entitled to fraud upon underlessee. That there is a fraud upon underlessee, I have a subsisting right as an underlessee, curtailing my right, this deed has been executed. But if you are unsuccessful on your principal point, which is the fraud upon underlessee, you can't, my lord, rely on a consequential relief. I'll show the plaint also. Now, my lord, kindly see J. On 4th June 2016, during pendency of title suit number 1405 of 2015, the defendant numbers 2 to 5 surrendered their rights and interest in respect of the said premises in favor of the plaintiff. Well, this is the pleading for fraud upon underlessee. I'll show the plaint also. Now, assume, my lord, this is true and correct. As a demurrer, I take it to be true and correct. Well, the whole question that I ask is, can you surrender non-existent rights? What is there for defendant 2 to 5 to surrender when, my lord, it is the admitted case of 2 to 5 that 2015 lease expired. It is an admitted case of D13 in the agreement itself that it has already gone. So one has entered into, my lord, there is a consent decree. 2 to 5 as per the own admission of the defendant number 13 has surrendered their rights. Now, assuming for a moment it is surrender, can it be a fraud when, my lord, the main right already expired? They are not saying they have any better right, 2 to 5 any better right after 2015. So, my lord, this is another admission that assuming 2 to 5 could have had any rights, they have surrendered it. Well, the next admission is at page 604, internal page 7. I'm sorry, my lord, I missed out. I should have placed, my lord. Kindly come back to 603. My lord, subparagraph K. The defendant number 1 filed title suit number 456 of 2017 before City Civil Court at Calcutta against the plaintiff, the defendant number 2 as well as the answering defendant, where an order of 12th April 2017, the learned court was pleased to restrain the plaintiff from encumbering or transferring or parting with possession or creating any interest in respect of the suit property. Then the order is the next. D1 is now inconsequential. That suit has gone because D1 itself we have a consent decree. Now I come to the next one. After expiry of the lease, dated 29 September 1965, the plaintiff filed the instant suit and subsequently arrayed the answering defendant as defendant number 13 therein by virtue of an order dated 19 November 2018. By an order dated 26 November 2019, subsequently confirmed by an order of 6 January, the answering defendant has been restrained from selling, encumbering or creating any third party. Well, these are orders passed in this suit. Now, M is very important. In view of the litigations and counter litigation in respect of the suit property, a cloud was cast on the rights of the answering defendant in respect of the said tenancies. We are pausing here for a moment. No cloud, my lord, on my right. Cloud cast on the rights of answering defendant. So, if somebody is admitting there is a cloud on my right, why should my judgment upon admission be refused? I read on further. Upon surrender by defendant numbers 2 to 5 in favor of the plaintiff, the answering defendant, though ready and willing to make payment of rents in favor of the rightful lessee of the said premises under the trust, was prevented from doing so by reason of the rival claims and litigation by defendant 1 and the plaintiff. In view of the order dated 12th April passed in title suit number 456, the answering defendant was restrained from entering into. Now, pausing here for a moment, my lord. 456 of 2017 has since been dismissed for default. That's my lord, defendant number 1. So, this can't be an embargo. Number 2, my lord, assuming this is correct, the admission is that cloud is on the title of defendant 13, on the right of defendant 13. And, my lord, surrendered rights also, my lord, it's what do you surrender if you don't have any right? That's, my lord, the basic question. And all these, my lord, no trial is required. The next admission, lordship will find. Not an admission, my lord, but facts. My lord, kindly come to page 606. The subparagraph R. I first showed, my lord, the suit of defendant number 1, which has since been dismissed for default. Now, my lord, I'll show, my lord, the suit of D13 itself. This is the reference to the suit.
Defendant number 1 suit has been dismissed for default or compromised?
My lord, so far as this suit is concerned, in this suit, D1, my lord, there is a consent decree.
I see.
And so far as, my lord, the city court suit is concerned, my lord, that has been dismissed for default. Now, my lord, I come to the next suit. That is, my lord, title suit number 1381 of 2018. My lord, my learned junior, my lord, rightly points out, my lord, kindly, my lord, before 606, kindly turn the previous page, 605, subparagraph N. In fact, my right has been recognized. Though the answering defendant was entitled to claim direct privity with the plaintiff upon surrender of the said tenancies in favor of defendant numbers 2 to 5, the plaintiff refused to recognize the answering defendant as such. On the contrary, the plaintiff started illegal attempts to disturb the settled and peaceful possession of the answering defendant in respect of the said tenancies. So, my lord, even their best possible case, they are claiming a direct privity with the plaintiff, that is me. That is, my lord, these are the foundation for making out a case of fraud upon underless. Now, these would have been perfect pleading if, my lord, the lease, the lease would have been subsisting. That you can have a direct privity with the plaintiff only if the head lease survives. The deed 225, they have exercised fraud upon me. The period was 50 years or period was 20 years. They have surrendered it without my notice. I am entitled to the residual period of whatever remains in the head lease. But all these pleadings are academic because of three admissions. Number one, the parent lease was 50 years. Number two, the next lease was from 89 or both terminated in 2015. And number three, I have shown your lordship the document, my lord, that is only for 3 years. But assuming you can claim, my lord, holding over or whatever, you can't have a right greater than what 225 could have had. Now, my lord, this is the prayer 606, my lord, are the reliefs in the suit at City Court. My lord, kindly see, my lord, relief A. Already admission that there is a cloud on their title or their right. And to clarify that, first is a decree of declaration that the plaintiff is a tenant in respect of suit property, either under defendant 1 or under defendant 2, subject to adjudication of rights in the pending litigation. That is the D1 suit, which is no longer there. And in this suit, my lord, there is already a compromise. So, my lord, this declaration is now of no value. Because, my lord, their best possible case is, I do not know who is the lessor, or I do not know why D2 to 5 have surrendered. I am entitled to have direct privity with me, plaintiff. They have a right to have direct privity with me. But that case, my lord, is also flowing from D2 to 5. That is there, my lord. I showed the earlier averments. So, my lord, this is, my lord, just for mere academics, my lord, it looks very impressive, but actually, my lord, it has no basis or foundation in law. And I am taking it, my lord, at face value. Then, my lord, the next decree for declaration that as part of plaintiff's tenancy right in the suit property, entitled to uninterrupted and peaceful use. My lord, this will only flow if, my lord, they are successful in prayer. And relief A, my lord, as of now on the admitted facts, it does not disclose any cause of action. And then, my lord, perpetual injunction. Then, my lord, on this, in this suit, Lord, lordship will kindly take the plaint itself so that, my lord, I may not be. My lord, 213 volume 2. But I will show admissions in their plaint also. The averment start from page 214. I just show your lordship, my lord, two paragraphs from the plaint. My lord, kindly come to page 216, paragraph 10. Paragraph 9 and 10. My lord, here defendant number 13 is the plaintiff in the city court suit. The plaintiff has been at all material times in settled, uninterrupted and peaceful possession, has been making due payment of rent to the suit property to defendants 8 to 11. My lord, 8 to 11 in the city court suit is 2 to 5 here. Then, my lord, para 10 is very important. Because this is the foundation on which, my lord, they are claiming their rights in the city court suit. It will appear from the agreement dated 1st April 2004, executed between the defendant numbers 8 to 11 as the lessors and plaintiff as the lessee, that under the said agreement, the said lessors demised in favor of the plaintiff portion of suit property more fully described in Schedule A to the plaintiff along with their rights to use and enjoy all rights and interests attached thereto, and the suit property has been described. None of the units demised in favor of the plaintiff, being those described as items A and B in the schedule, has any private toilet, lavatory, so and so, at all material times using the common so and so in northeastern side of the 10th floor for their purpose. Then next para. The said agreement dated 1st April 2004 expired by efflux of time on 31st March 2007.
Yes.
However, the plaintiff uninterruptedly continued in settled possession and occupation of the portion so and so. On one hand, you are claiming tenant sufferance. On the other hand, you are pleading the defense is fraud upon underless. So, this is the plaint, my lord, in City Civil Court. Now, my lord, I show your lordship the order because, my lord, the learned judge, my lord, said that because of the order of the city court, my lord, summary decree can't be passed, and my lord, because status quo was there, my lord, 275, lordship will see, my lord, what is the order that was passed. 275 is the main order and 275A is the typed copy. This is the order dated 10th October 2018. And I'll take the order at its face value. This is order dated 10th October 2018. Issue notice on the defendant numbers 1 and 2 asking them to show cause within so and so. The date of why order of temporary injunction as prayed for should not be granted. Then this is important. In the meantime, considering the submission of the learned advocate for the plaintiff coupled with materials available on record, it appears to me there is some urgency to pass an ad interim order of injunction in the form of status quo. And if no such order is passed, the object of granting injunction would be defeated by delay. Accordingly, defendant numbers 1 and 2 are directed to maintain status quo as on this date in respect of suit property with regard to, my lord, kindly marks the expression, nature, character and possession. There is no status quo, my lord, restraining me from filing a suit or, my lord, seeking eviction decree. And in any event, ours is a prior suit. So, nature, character and possession, they are still in possession. And, my lord, if I am successful in getting a decree, I will execute it. The question will be, my lord, whether the status quo order can prevent an execution of a validly passed decree. It's well settled, it cannot. So, why, my lord, for this, I should be asked to go to trial?
This was the only ground for
the learned judge, my lord, twofold grounds have, my lord, have been considered, my lord, and my lord, the learned judge felt that these are the two grounds. One is fraud on underlessee, and one is the status quo order saying that I have suppressed it. There is no other ground. I'll come to the impugned order. So, my lord, this is the order of City Civil Court. My lord, identical, my lord, defendant number 14. I am not, my lord, just multiplying it, my lord, there are identical agreement, there is a suit, and my lord, so far as defendant number 14 is concerned. Now, my lord, kindly straight away come to the order impugned. Lordship can just for, my lord, formality make a note, my lord, the written statement of defendant number 14 starts at page 618 and the relevant admission is at page 621. similar in nature as that, my lord, where the 6-1. It's my lord parameteria with what D13 has taken.
Yeah.
That impugned order, my lord, is the
Just,
volume.
Mr. Chaudhary, give us the suit TS number of D14,
Yes,
the one that he has filed.
6-1. 6-1. Suit number ta page. Right, its title suit number 1382 of 2018. 1382 of 2018.
That's by defendant number 14.
And similar, this is the problem. You see, somebody suddenly from nowhere, no, the similar order, similar status quo order.
And my lord, the averments are also, my lord, same parameteria. That declaration and, my lord, it's same. Facts pleaded are also same. And one kindly comes to the order under appeal, which is at page 457, volume 4.
Memo.
আমি তো আমারটার থেকে দেখি agreement was for 2 years, my lord. They have themselves admitted the agreement expired in 2007 itself. But my lord, assuming for a moment they can continue either as holding over or otherwise, my lord, maximum is 2015. They can't continue more than that. Counsel for the plaintiff submits that defendant number 14 in his affidavit in opposition mentioned that right of the defendant number 14 flows from defendant numbers 2 to 5. The defendant number 1, whose lease has expired on 30th September 2015 by efflux of time, admitted the terms of settlement arrived between the parties. In the said terms, it is recorded that plaintiff has become the rightful lessee after expiry of the 1965 lease. The determination which took place by efflux of time on 30th September 2015. The counsel for the plaintiff submits that the plaintiff is entitled to decree against the defendant number 1 by virtue of the settlement. The counsel for the plaintiff submits that right of the defendant number 1 being admitted arising out of the registered lease which expired on 30th September 2015. The plaintiff's right is also admitted, and thus the plaintiff is entitled to a decree as against the defendants even on admission of the said fact as recorded in the terms. Counsel for the plaintiff submits that defendant 13 and 14 are claiming their right to defendant numbers 2 to 5 as sublessees, and the lease of defendants 2 to 5 have already been determined by efflux of time on 30th September 2015, and as such, the plaintiff is entitled to get a decree on admission.
Before you proceed further, just for clarity of thought, the learned judge refers to other defendants as well, 11, 15, and 18. Are they not in possession anymore?
Well, so far as they are concerned, most of them have surrendered. We are now only concerned with 13 and 14.
Only they are in possession.
Only 13 and 14. Because, my lord, only 13 and 14 contested it, and, my lord, their challenge, my lord, so far has been successful. That is why we are before your lordship. Initially, my lord, there were right from 11 to 19, my lord, they all were under 2 to 5. But, my lord, now, my lord, the only two contestants are there, 13 and 14, against whom we have to get a formal decree. Then, my lord, counsel for the plaintiff submits it well settled law, my lord, order 12, rule 6, and, my lord, we refer to the case of Uttam Singh Dugal and Payal Vision. That unnecessary trial for the sake of formality, my lord, should not be, my lord. The defense has to be seen that you have no chance of success if you can make out such no chance. No question of moonshine. That on the, if you take it to be true, whether it has any chance of success, it has no chance of success. Counsel for, now this is important. After the citations, let us see what their submissions were. Counsel for the defendant 13 submits, plaintiff has entered into a terms of settlement with defendant number 1, wherein defendant number 1 has admitted that the lease in the suit premises in its favor has expired by efflux of time on 30th September 2015. Plaintiff is the rightful lessee, and the plaintiff has right to collect occupational charges from unauthorized occupants of the suit premises. Defendants 2 to 5 in their affidavit in the instance suit have admitted they have entered into an agreement dated 18th August 89 with D1 and obtained sublease of the suit premises, and lease in favor of the defendant number 1 has expired on 30th September 2015. Apart from the two instances, the plaintiff has not relied upon any other instances of alleged admission for the purpose of getting a decree on admission. We are pausing here for a moment. The submission which has been accepted by the learned judge, that whether there has to be a separate admission by defendant number 13, that I am a trespasser. With respect, law doesn't require that. Once you admit I am claiming right from X, and X admits that I do not have any right, it is axiomatic. No trespasser is going to come up in affidavit and may not say that I am a trespasser, and then only a decree will be passed. No court will ever be able to pass a decree if, my lord, the principles of unambiguous admission is taken to that level. That the trespasser will come and say on affidavit, I am a trespasser, evict me please. And then, my lord, that will be, that is not. But all that, my lord, judgment upon admission is whether there is an admission of fact or not. And if these facts are admitted, assuming that you have a plausible defense, do you have any chance of success? So, my lord, my entire submission, both before the first court and before your lordships, are that assuming, my lord, whatever they have said in black and white is correct, Lord, do they have any chance of success? My respectful submission is in the negative. And I don't require, for all these facts, I don't require to go into trial. I don't have to go to trial to show 50 years was the lease. I don't have to go to trial to show that the sublease has also expired in 2015. All are admitted, so it won't be an issue. So if I don't have to go to trial to prove any of these facts, why should my application for judgment upon admission be refused? Let us test it further. Counsel for defendant number 13 has pointed out the following undisputed fact between the parties. Now, my lord, kindly see subparagraph F and G, which has been highlighted. Even after expiry of lease dated 1st April 2004, the defendant number 13 continued in possession of its portion of suit premises. Rent was tendered and duly received by 225 till January 2016. And that this has been highlighted. What difference does it make so far as I am concerned? Tenant by holding over or sublessee by holding over, let us assume that's the best possible case you may have. That also goes after 2015. Can they make out a case? 2 against 225. Assume for January, my lord, they take it. Lease has expired in 2015. 225 doesn't have any right. And they are also saying that 225 doesn't have any right. And their case is, I have direct privity with the plaintiff. That's the case made out. They are seeking direct privity with me. But this is the pleading. And this is, my lord, these have been highlighted by the learned judge. The defendant number 13 continued in occupation of its portion of the suit premises as a tenant by holding over from month to month at last paid rent of 6361. Holding over, my lord, for whom? Against whom as the landlord? 225. How can you hold over against 225 who itself does not have any right? And I don't have to lead any evidence for this fact. Counsel for defendant 13 submits in the year 2013 when the plaintiff started creating disturbance in the suit premises. The defendants 225 has instituted title suit 1405 against Learned City Civil Court during pendency. Defendants 225 have fraudulently surrendered their possession in favor of the plaintiff. Let us take it at the face value. After 2015, can there be a fraudulent surrender? What is there to surrender if I don't have a right? I can only surrender something which I have. 225, my lord, as per their own admission, did not have any right after 2015. So, what did they surrender? And how can that be a fraud? Assuming, my lord, that
they had till 29 September 2015.
Correct. Counsel for defendant 13 submits defendant number 1 file title suit wherein Learned City Civil Court in the said suit granted an addendum order. My lord, I placed that order itself. The plaintiff was restrained from entering into any arrangement with defendant number 13 and defendant number 13 was restrained from creating any interest in respect of any tenancy in favor of the plaintiff or any third party. Well, this was against D1. Well, that suit has already gone. Counsel for defendant number 13 submits plaintiff has filed the instant suit by impleading only defendant 1 and defendant 13 was not made party and subsequently the plaintiff had impleaded 13 and 14. Well, what is wrong in that? I have impleaded him subsequently because they were in actual possession. D1 is not seeking any right. Originally, my lord, if I get a decree against the main defendant, my lord, Lordship knows under Order 21, Rule 35, my lord, anybody who claims under the, my lord, judgment debtor is bound by the decree. But be that as it may, I have for abundant caution impleaded them as parties. They have filed their written statement. How can this be a triable issue or a defense? My virtue is being converted into my vice. The fact that I have abundant caution, I have not done anything behind my back. Even if I wouldn't have implemented them, I would still be in a position to execute the decree. The counsel for the defendant submits the defendant 13 file title suit at Learned City Civil Court for declaration of tenancy right and protection of its possession. In the said suit, there is an order of injunction where the Learned City Civil Court directed defendant 13 and D1 to maintain status quo with regard to nature, character, so on. So, my lord, one breath of argument may be that the fact that D1 has entered into a compromise here, that is in violation of status quo. Nature, character, my lord, of the possession, their possession is still today the same, and they are claiming, my lord, at best possessory rights. Well, how is this relevant? That is why I read the order of status quo. The counsel for the defendant 13 submits plaintiff has filed the purported terms of settlement with defendant 1 in title suit, but the settlement has not yet been admitted by the learned court. The counsel for the defendant submits plaintiff has failed to demonstrate any semblance of such admission on the part of the defendant number 13 and prayed for dismissal of the instant application. Well, these judgments relied upon are all on the principles of, my lord, that judgment upon admission should be unambiguous, clear, unequivocal. Well, these are well settled principles. I am not. Only issue is, shall the admission have to be of a nature where, my lord, a trespasser will admit himself to be a trespasser? Or is it sufficient that you make admission of facts, the legal consequence of which is you are a trespasser? My respectful submission is, it's the latter. Then, my lord, defendant numbers 14 submission are also, my lord, similar. Additional one is, my lord, specific reference to 115. I must show that. My lord, internal page 9. Second para onwards. Counsel for defendant 14 submits, right of the defendant 14 will be decided in suit pending in city court, and any decision of this honorable court as regard right of defendant 14 will make the suit filed by defendant number 14 infructuous. But assuming for a moment, there is identity of issues, or, my lord, the issues here can be said to be directly and substantially in issue there. Well, firstly, that's a later suit. You could have asked for stay of trial. Can you ask that? Because, well, it's not. It's a declaration and injunction. That suit, that city court will not decide, my lord, my entitlement for eviction. They won't be able to plead, my lord. We won't be able to urge that there also, because, my lord, they don't have the jurisdiction, at least at that point of time. Because, my lord, of the valuation and all that. And, well, same, my lord, the judgments have been referred to. Last paragraph. Counsel for the defendant 14, by referring section 115 of Transfer of Property Act, submits that surrender of lease does not prejudice an underlessee of the property or any part thereof previously granted by the lessee. Kindly have a look at section 115 of the Transfer of Property Act. I'm sorry. This is what, my lord, I was referring to in law, my lord, we know as fraud on underlessees. अच्छा, ट्रांसफर ऑफ प्रॉपर्टी एक्ट अच्छा अच्छा नहीं जज साहब का कॉपी नहीं iPad থেকে খুলে দেন. May I hand up to your lordship, my lord? I am grateful to my learned friend. She has given me her copy, and I'll give mine, and I'll. Oh, lordships have got. So, my lord, the first principle is 115 applies only in two cases: surrender or forfeiture. There is no case of forfeiture here. It's a case of, at all, at best, it can be a question of alleged surrender. Now, to surrender, my lord, 115 will only operate when there is a parent subsisting head lease in favor of the lesser. And disregarding that lease, my lord, the head lesser surrenders, which jeopardizes the right of the underlessees, because they have entered into the sublease knowing that my lesser or my lesser or sublessor has a right for so many years.
Yes, you have said, Mr. Chaudhary, if there's nothing to surrender, where's the question of surrender?
My lord, I just read one, my lord. Surrender express or implied of a lease of immovable does not prejudice an underlease of property or any part thereof previously granted by the lessee on terms and conditions substantially the same, except as regards to amount of rent as those of the original lease. But unless the surrender is made for the purpose of obtaining a new lease, the rent payable by and contracts binding on the underlessee shall be respectively payable. So, my lord, my first submission is this has no application because the contract is not binding. There is no binding contract because the head lease is no longer there. Then, my lord, the reasonings now come. Internal page 10. I read from the second para. Plaintiff has prayed for judgment on admission on the ground plaintiff entered into terms of settlement with defendant 1, wherein defendant number 1 admitted the lease of the suit premises is expired by efflux of time on 30th September, and the plaintiff as the rightful lessee of the premises. The defendant numbers 2 to 5 admitted in affidavit in GA so-and-so in connection with the instant suit. Have entered into an indenture of 18th August with the defendant number 1, whereby the defendant number 1 as a sublessor created sublease in the suit property in favor of 2 to 5. It has also been admitted by defendants 2 to 5 that lease in favor of D1 expired on 30th September. As per the submission of the counsel of defendant numbers 13 and 14, no decree can be passed if an order of injunction is in existence. The settlement entered between two parties, third party cannot be given effect to. The plaintiff is in collusion with other parties, and the plaintiff has not disclosed the order of status quo in the plaint, in spite of having knowledge about the same to the plaintiff. It is further the case of the defendants that as per section 115 of the contract, surrender of lease by D2 to 5 will not affect the right of 13 and 14. Then, my lord, order 12, rule 6 has been quoted. My lord, the terms of settlement with D1 has been quoted. The terms of settlement has been quoted at 467. Lordship can make a note. The actual terms are at page 111. And my lord, I just read from, I'm sorry, internal page 11, my lord. Paragraph 3 of the terms of settlement. The defendant number 1 has accepted the plaintiff's right to collect, recover unauthorized occupational charges, so on. And my lord, para 2, my lord, they have admitted that the lease has been determined by flux of time on 30th September. Then, my lord, internal page 12. My lord, in the terms of settlement at internal page 11, my lord, I just also read, my lord, paragraph 4 of the terms. It is made clear that subsequent to filing of these terms of settlement, the respective parties, the plaintiff and the defendant number 1 will have no claims against each other pertaining to issues involved in CS 85 of 2016.
CS 85 is your suit?
Yes, my suit. This suit. In the suit filed by defendant 13 against the plaintiff and others, being title suit so-and-so, defendant number 1, that is the plaintiff, and defendant number 2 have entered into a settlement which reads as follows. Well, a similar settlement in the city court suit also, that we have, that the lease has expired by efflux of time, and my lord, they accept our right. The terms have been quoted. Then, my lord, kindly come to, my lord, the main reasoning starts at internal page 13. Admittedly, lease was granted in favor of defendant number 1 by the trustees of Raja Rajendra Mullik Bahadur on 19 September for a term of 50 years with effect from 1st October 1965. During the subsistence of the said lease, the trustees of the trust have entered into a lease with the plaintiff on 31st March 2001 in terms of the order passed by the Honorable High Court. And in the said lease deed, it is mentioned that the lease deed will be commencing from the expiry of the earlier lease deed entered into between the defendant number 1, that is from 1st October 2015. The defendant number 2 has affirmed an affidavit in connection with GA 407, wherein the defendant numbers 2 to 5 have admitted that defendant number 1 had entered into a sublease with defendant numbers 2 to 5 on August 1989 with respect to the suit property, and the said deed of lease expired on 30th September 2015. So, my lord, all these admissions are also accepted as admissions by the first court. It is also an admitted case of the defendant numbers 13 and 14 that in the year 2004, defendants 2 to 5 have inducted them as sublessee, and the period of sublease expired in the month of March 2007. But the defendant numbers 13 and 14 uninterruptedly continued in settled possession and occupation of the portion of suit property upon rent, and rent receipts are enclosed in affidavit in opposition, which reflects that defendant 13 and 14 have paid rent till the month of January 2016. Then, my lord, 13 and 14 have filed title suits in the Learned City Civil Court, obtained an order of injunction. Then, my lord, internal page 14. The judgment referred by the plaintiff in case of Uttam Singh Dugal, the Honorable Supreme Court held that the object of the rule is to obtain a party to obtain speedy judgment, at least to the extent of the relief to which, according to the admission of the defendant, the plaintiff is entitled. In the case of Pile Vision, the Honorable Supreme Court held that, my lord, it has been quoted. And then, my lord, kindly see the judgment referred by the defendants. In the case of Himani Alloys, Honorable Supreme Court said, but the admission should be categorical. It should be a conscious and deliberate act of the party making it, showing an intention to be bound by it. The court, on an examination of facts and circumstances, has to exercise its judicial discretion, keeping in mind that a judgment of admission is a judgment without trial, which permanently denies any remedy to the defendant by way of an appeal on merits. Therefore, unless the admission is clear, unambiguous, and unconditional, the discretion of the court should not be exercised to deny valuable right of a defendant to contest the claim. In short, the discretion should be used only when there is a clear admission which can be acted upon. Now, my lord, this admission, it was submitted that there is no admission by me that I am a trespasser. Now, if that is the test of admission, my lord, I also don't succeed. And in fact, my lord, no landlord will succeed against any trespasser, because no trespasser will come and say on affidavit that I am a trespasser. All that, even on 106 cases, my lord, the admission is, once you admit the receipt of the notice under 106, that is sufficient to pass a decree. That's because that's the only triable issue, that whether notice has been validly served, terminating it. Here, my lord, the facts, the learned judge himself has recorded in the order that these facts are admitted. Now, my lord, I come to this, because, my lord, the question will be, what will they contest on trial? I don't have to prove any of these facts, and I don't have to prove anything more.
They are not claiming any independent right.
No.
Paragraph 10, they admit.
Well, para 10, I showed your lordship.
If they were claiming independent right, then you're...
Then perhaps. Well, in fact, they are claiming a direct privity of right with me, and their case is, I do not know if D1 whom to give the rent, D1 or plaintiff. Then, my lord, the case of, my lord, Beryl Murzello, Bombay High Court held that, my lord, I read this, my lord. Kindly see, my lord, the underlined portion. In fact, I read the para. Being so, in case wherein the plaintiff himself approaches the court, stating that on account of certain acts on part of the concerned defendant, third parties are claiming some right in the property in question, and on that count, those parties are joined as defendant to the suit, merely because one of the defendant has made some admission regarding the claim of the plaintiff, unless the rights which have been claimed by the third party through such defendant are adjudicated upon, it would be too premature for the court to decree the suit in relation to such property merely on the basis of an admission made by the concerned defendant. But here the third party has to claim an independent right, or will have to show that third party, even if they're claiming to the defendant, my lord, their right has become independent. For instance, my lord, fraud upon underlessee. Underlessee will be a third party if they are not made parties. But they'll have to show, my lord, that because of the fraud, their right has become direct. Here, my lord, on their own showing, that 115 doesn't apply at all. And that's what, my lord, I had argued before the first court, that where is the case of fraud upon underlessee when there is no head lease? Because it applies only in case of surrender and forfeiture. Then, my lord, Jasbir Singh Chadda, my lord, I have no dispute. It's a question of fact. It cannot be decided on judicial precedent. And then, my lord, Shantes has been referred to. My lord, I read the paragraph quoted because the underlining portions have been, my lord, the emphasis has been laid by the learned judge. It is not proper for the court to pass a decree on inference. Admission has to be unambiguous, clear, and unconditional. And law would not permit admission by inference as it is a matter of fact. But pausing here for a moment, my lord, my entire case is on admission of fact. And the only inference in law is that if the head lease goes, the sublease goes, how do you stay? That's only inference in law on facts. In fact, I won't call it an inference in law, my lord, it's a conclusion in law. That if you admit that the head lease has expired in 2015, you admit D225's lease has expired in 2015, the only conclusion is they don't have a right and you don't have a right. And you have not pleaded any independent right to go for trial. Then, my lord, Mehta Suryata is also on the same principle, my lord. I am not disputing the propositions. Same with Tiratram Gupta, my lord, the celebrated case. My lord, there, my lord, the question was on admitted facts, my lord, whether it was, my lord, tenancy statutory rights were getting, my lord, whether rent control protection was there or not. All these questions are involved. And then, my lord, Ramchandra Singh has been quoted, internal page 18. Paragraph 35, my lord, may I read? The consent order, as is well known, is an agreement between the parties with the seal of court superadded to it. The appellant herein in the review application categorically stated that parties to appeal had suppressed the auction sale as also the confirmation thereof. The effect of events appearing subsequent to filing of the first appeal resulting in creation of a third party right was bound to be taken into consideration by the High Court. A third party right cannot be set at naught by consent. The High Court therefore was required to consider the contention of the appellant in proper perspective. Well, here everything has been done. I have pointed out how they have come in. And they have admitted that I have come in QA D1, QA D2 to D5. How are these ratios applicable? And my lord, it's a question of fact. Then, my lord, comes the conclusion of the learned judge, my lord, with greatest of respect, my lord, is perhaps not correct. In the present case, the defendant 13 and 14 have specifically averred with regard to fraud and collusion in the suit filed before the City Civil Court at Calcutta against respondent 2 to 5, stating that 2 to 5 have fraudulently and in collusion with the plaintiff surrendered the suit property. But I have already made my submission vis-a-vis surrender. Can he disclose a cause of action once you admit that the head lease has expired? And the said suits are pending before the City Civil Court for adjudication. The defendant numbers 13 and 14 also made out a case. The defendants are in occupation of the suit property and have paid rent to defendants 2 to 5 at the rate of 6,000 and odd. and rent receipt enclosed with the affidavit is with January 2016. In the said suits, the defendant have also obtained an order of status quo with regard to nature and character of the suit property and restrained from creation of third-party interest over the suit property. As the defendants have taken the ground of fraud and collusion between the plaintiff and the defendants 2 to 5, and thus the judgment referred to by defendants are applicable in the instant case. But firstly, I am not a third party to the suit. So I am not violating any order of injunction. It is my property, or at least I have a right on that property. And nature and character, my lord, they are still there. Possession with respect to possession. And this is by due process of law. The defendant 13 and 14 have narrated facts of the case of settlement entered into the plaintiff and 2 to 5, but defendant 13 and 14 have not admitted with regard to the contention made by the plaintiff against defendant 13-14 in the instant application or plaint. They have only not admitted that they are trespassers, but all the facts they have admitted. On the other hand, the defendant numbers 13 and 14 have filed their respective suits against the plaintiff and others for declaration as a tenant, and in the suit the defendant has also obtained an order of injunction, and thus the defendant's judgment referred by the plaintiff is distinguishable. So there is no order of injunction. It's an order of status quo with regard to nature and character.
You showed us. You are a party in those two suits. The plaints are on record. Plaints in the city court suit.
I showed your lordship one such plaint.
Yes, you did.
216, 213.
213.
And my lord, the other is at page. Other plaint is not there, but my lord, it's almost identical. 213. In fact, my lord, since it's fallen from your lordship, my lord, I showed your lordship, my lord, the two pleadings. Para 10, in fact, I showed your lordship. Welcome. Yes, paragraph 10, my lord. Kindly see. That paragraph 4, my lord, the head lease is pleaded. 50 years commencing from 29 September 1965. Then, my lord, the express power to sublease has been pleaded in paragraph 7. And then lordship will find, my lord, how 2 to 5 come into the picture. 2 to 5 here, my lord, is defendant 8 to 11 in the city court suit. And para 10 is that agreement of 1st of April. And my lord, para 11, agreement expired by efflux of time on 31st March 2007. They have admitted that their agreement has expired. উত্তম সিং গুগলটা আছে
So he claims a declaration that he is a is a tenant either under you or under Orient Beverage.
Now, my lord,
Now that is rightly or wrongly, that's a prayer.
I am not on right or wrong, my lord. Let us assume the facts stated therein are correct. Well, I am treating it as a demurrer. My lord, whether I am entitled to rejection of plaint for non-disclosure, that's a different issue. But now, my lord, in the teeth of admission of all these facts, Lord, will this suit of mine go to trial? That's the question. In the teeth of admission of what has been stated in the plaint, even in the city civil court, why should...
We'll come back.
I'm praying for leave to file one appeal without certified copy. Determination of Honorable Chief Justice.
When was the order passed?
Day before yesterday.
Granted. GP determination. it at 2 p.m. Shouldn't take too long.
We found the affidavit of service.
Give it.
This
Call
was-
that matter.
When the appeal was filed.
Item number 11.
I'm sorry. When the appeal was filed, there was a direction on us to serve by way of substituted service. We've served. The man was selling turmeric bulbs, like turmeric. So, and now he's disappeared. So he has not even come to execute the
Bulbs or bulbs.
BULBS. bulb.
BULBS.
So that's the thing. Well, the decree will grow into turmeric plants, I suppose. I don't know. But it's unfortunate one, but the decree was passed, page 75, 3rd June 1996. And it only follows the direction of the division bench order.
Yes, we have seen there's no adjudication, Mr. Ghosh.
Absolutely no adjudication. And no attempt to prove the damages or what was the value, etc.
No.
There's on a separate point, no section 80 notice also. We are the state. And there was no finding against the state in the writ petition. That's it.
देखो issue. This appeal is directed against a judgment and decree dated June 3, 1996, passed by a learned judge of our court in suit number 551 of 1987, bracketed out Messrs. Vikash Trading Company. It's a proprietorship or a partnership?
Proprietorship, looks like.
Versus the Union of India and others, bracket closed. Whereby the suit was decreed against the state of West Bengal, bracketed the appellant herein, for a sum of rupees 2,93,600, along with interest thereon at the rate of 18% per annum until payment. Top paragraph. Pursuant to an order dated March 23, 2015, after this substituted notice service,
Nothing.
this matter was never taken up.
No.
What should I do? This affidavit was the
9 years, 2015.
Address to me. This is the only thing that's troubling me. We are going to set it aside, whether they come or not. 10 years ago, this service was made.
I appreciate it. Like your lordship says, because of your lordships, it's come up, the appeal has come up now.
So, sir, once again, what to do?
About paper publication.
The money is there in the thing.
Yes.
Even if he comes, I'll get it settled. It's 2.5 lakh.
Yes.
Unless he insists on 18% interest of not. Seems like a farmer. I don't know.
Local paper publication.
So you will effect service by paper publication.
Was done.
Yes.
It was done in local language also.
Same thing left.
কি বললাম?
Or your lordship only way I can help my learned friends are your lordship will dictate what is required to be published. So it's less. Otherwise, if the whole cause title, etc., like was done before.
Short cause title, case number, and that this appeal is coming up for hearing, or we'll give a date.
Yes. Your lordship will keep it any day.
23-2015 passed in this appeal by a coordinate bench, substituted service was effected on the respondent by way of newspaper publication in view of the fact that the postal service that was attempted had failed and the envelope was returned with the remark, quote, addressee left the address, stop, unquote. Paragraph. We see that 10 years have elapsed since that service was effected, that substituted service was effected. Stop. It would be proper to serve a fresh notice on the respondent. Paragraph. Let such notice be served by paper publication in a local newspaper, having good circulation in the locality.
Address in the cause title.
Uh,
Erode. District Erode, Tamil Nadu.
In the locality where the respondent resided as per his last known address.
Or carried on business. No? It's a
Carried on business. Resided, carried on business. As per the last his last known address. Stop. The publication should only mention the appeal number, short cause title, and that the matter will be listed before this court. Once again, on how long will you take?
8 weeks. 6 weeks. That will be part of.
What part of no?
Otherwise, we lose one judge.
No part of.
So Lordship heard it. It's for setting aside. I just want to be fair to this man. It's a small decree.
Yes, yes. Whichever bench it is, it's very likely to be set aside. 6 weeks hence. 6 weeks hence করে ডেটটা বলে দাও। No.
6th of. Great.
Item 21.
But I was
Yes.
the last 2 pages of the order under appeal. Internal page 19. Lordship was
Yes.
looking at the order from the memorandum of.
Yes, yes.
Second paragraph. The defendant numbers 13 and 14 have narrated the facts of the case and settlement entered into between the plaintiff and the defendant numbers 2 to 5. But defendant numbers 13 and 14 have not admitted with regard to the contention made by the plaintiff against defendant 13 and 14 in the instant application or in the plaint. We are pausing here for a moment. What is the case left for them to admit? Because they admit my case that their rights are flowing through defendant 1 and defendants 2 to 5. And this portion of the case has been admitted, which the learned judge has also come to a finding. Well, kindly compare this with the finding of the learned judge at internal page 13. The first 2 paragraphs. Admittedly, lease was granted so-and-so, expires so-and-so, all admitted. It is also admitted case of defendant 13 and 14. They entered into in 2004, which has expired in March. Uninterrupted settled possession. This is the case. Now, this can be at best a tenant in sufferance, uninterrupted settled possession. If a landlord is there who is the owner, this can't be a defense as against me. When they are admitting that 225, they are saying their rights are flowing to 225. Had 225 filed against them, they can say tenant by holding over, consent or no consent, all these are issue. But it can't be. But I come back to internal page 19, distinguishable. Now, my lord, the last portion of the order, my lord, this is, my lord, apropos. But if lordships, my lord, kindly comes to page 15, volume 1, my lord, I'll show your lordship what were the prayers in the petition. But I made a mistake in the beginning. I said that, my lord, the prayers were only judgment upon admission against 13 and 14. There was another prayer which was refused, and they were the only two outstanding prayers. One was, my lord, for passing a decree in terms of the terms of settlement as against defendant number 1. That was also refused because of the defense setup, and my lord, that is why the last paragraph. So before I place the last paragraph, I must show your lordship in all fairness. At page 15. So this was a composite application. Prayers A to D were already earlier passed. Well, that was at the ad interim stage already passed. So A to D we were not. The issue that was, my lord, we were really concerned with prayer E and prayer G. F is, of course, declaration I did not require. We had pressed for prayer E and prayer G. E is, my lord, decree be passed against defendant 1 in terms of the terms of settlement. And, my lord, G was judgment and decree. Well, at that time it was against, but well, ultimately it was only against 13 and 14. So we were concerned with E and G. Now I made my submissions apropos G. So far as E is concerned, well, the terms of settlement are at page 111, and that has been also set out in the order under appeal. It's a signed terms of settlement with defendant 1. Because, my lord, fraud on underless was pleaded, my lord, the learned judge, my lord, refused to even pass that. Because submission was made that this will amount to fraud. When, my lord, the admitted case is that the lease has expired, and that is exactly what defendant 1 has said. Kindly see page 111. The terms are quoted, and it's quoted, but just for formality, I am showing, my lord. Orient Beverages. Defendant number 1 has accepted plaintiff as rightful lessee of premises so and so after the determination of lease of the defendant number 1 by efflux of time on 30th September 2015. And this factual position has been admitted by defendant 13 also in their agreement. The first recital records that. So, my lord, I come back to internal page 19. In exercising the discretion under order 22 rule 3, the court has to satisfy its judicial conscience. Unlike other instances of exercise of such discretion by the court. Secondly, the admission must be clear, unequivocal, unconditional, and unambiguous. So there may not be necessity for the court to wait determination of other question. Thirdly, the admission must be taken as a whole unless the part of which the court proposes to allow on admission is severable from the parts of plaintiff's claim. My lord, with respect, my lord, if I may apply this, what is more unequivocal or unconditional? If, my lord, I go back again to, my lord, internal page 13, if these two paragraphs are admitted, and that is the finding of the judge that it's an admitted position, is there any other determination left? These two paragraphs are admitted by the learned judge on appreciation after seeing this. If these two paragraphs are admitted, well, what do we await determination?
You may be quite right, Mr. Chaudhary, in this suit. Nothing more, perhaps.
Now, my lord, let us test the city court suit. I'll come back because, my lord, lordship referred to that. But kindly come back to 213. But I am taking it a demurrer. I am taking that a demurrer. Let us assume there is a triable issue there. Well, firstly, it's a later suit. It's a later suit. That cannot in any event, my lord, affect any of the issues over here. Secondly, the order is only status quo with regard to nature and character of possession. Their case is I am in settled possession, not that I have a settled title or I have a title or a right. I'm going to take that plaint on face value. They can only establish in city court, my lord, what they have averred that is identical to what has been stated here as a defense.
But they do claim a declaration of tenancy.
Correct.
Under either you or Orient.
Correct. Now, my lord, so far as in both the cases, my lord, their rights are flowing from that agreement itself. My lord, if that is a case, then my lord, everyone will file a declaratory suit there, and my lord, the eviction suit will be kept pending, awaiting trial. My lord, kindly visualize under section 41 of the Specific Relief Act, my lord, they can't get an injunction on me to file any suit. That is impermissible in law. Assume for a moment the city court suit was earlier and my suit was later. Factually, here is not. I am putting it at the best possible. They can't get an injunction on me, my lord, restraining me from filing a suit for eviction. That's not possible under 41 of the Specific Relief Act. Injunction restraining me from filing a suit. This suit is a prior in point of time, number one. Number two, my lord, there is no order of injunction. If no order of injunction can be passed restraining a suit, can, my lord, that pendency of the city court suit be an embargo in passing a decree? Let us assume today after trial we are coming up before your lordship. Could this be set up as a defense? That city court is pending, don't pass a decree?
No, not that. If your suit goes to trial, the proper course may be to have analogous transfer it and to have analogous trial.
I am not on that because, my lord, this will be a ploy. Analogous, if it is transferred, firstly, why should my suit go to trial? Lord, I am just asking the question to myself. Lord, what do I, in view of the finding of the learned judge in these two paragraphs, Lord, what will my evidence, my witness, go in the box and say further? He does not have to say anything because, my lord, these are, my lord, now in black and white. It's an admitted position on the finding of the judge. Then, my lord, what more clear admission do I require? Now, my lord, kindly see what is the test. Unfortunately, my lord, from Uttam Singh Dugal, my lord, the learned judge, my lord, has not quoted the proper portion. My lord, kindly see, my lord, why we refer to this. My lord, in 2000, this judgment upon admission field was broadened. And, my lord, it was made, I won't say identical, but akin to what our tests are of chapter 13.
Mr. Sinha wants to ask you whether between the two of you, you will keep this court occupied till 3:30.
It should be. I'll finish in 10 minutes, my learned friend.
You will take the rest of the day.
All other matter it is for the day.
Now, my lord, kindly see, my lord, we cite this decision often, but, my lord, the last line. But at the cost of repetition, my lord, kindly make a note of internal page 13 with internal page 19. But I can't, my lord, suffer this finding after the finding at internal page 13. And, my lord, the learned judge, my lord, in Uttam Singh Dugal is referred to that, but, my lord, kindly see, my lord, the paragraph which I had cited. File vision was quoted, but Uttam Singh Dugal was not quoted, though referred to. But you will see the reference of Uttam Singh Dugal at internal page 14 of the judgment. Speedy judgment only, my lord, was referred to. But my lord, the Uttam Singh Dugal quotation was not there, but this is important. Paragraph 12, lordship will kindly see. This is my lord 2000 volume 7 SCC 120. And this is where, my lord, the earlier view, clear, unambiguous, my lord, the principles of chapter 13A indirectly, my lord, came in over here. That the test is, it is impossible for the party making the admission to succeed. That has to be the test, whether it is possible or impossible. As to the object of Order 12, Rule 6, we need not say anything more that what the legislature itself has said when the said provision came to be amended. In the objects and reasons set out while amending the said rule, it is stated that where a claim is admitted, the court has jurisdiction to enter a judgment for the plaintiff and to pass a decree on admitted claim. The object of the rule is to enable the party to obtain a speedy judgment, at least to the extent of the relief to which, according to the admission of the defendant, the plaintiff is entitled. We should not unduly narrow the meaning of this rule, as the object is to enable a party to obtain speedy judgment. Where the other party has made a plain admission entitling the former to succeed, it should apply. And also where there is a clear, well, it is admission of facts. This is the test, not admission of contention or admission of law, admission of facts, in the face of which it is impossible for the party making such admission to succeed. Well, I am putting my case that high that in view of the admissions, which has also been recognized by the learned judge in internal page 13 of the judgment, the first two paragraphs, it is impossible for my learned friend's client to succeed in the event there is a trial. Because what in trial will you show extra? These are the facts. So, on what basis? Because well, at fraud on underless, I have already said on these facts, in law it is not sustainable. I am not, well, trial is only for ascertaining a disputed question of fact. No question of law, no disputed question of law is raised. So, on these admitted facts, whether it is possible for them to succeed. Well, Lordship knows that moonshine defense theory, my lord, which is borrowed in chapter 13A, we often do and all that. Earlier, my lord, there was a dichotomy, but my lord, after post Uttam Singh Dugal, my lord, this is the test. Indirectly, it has come in. Iota of defense in trial possibility, even if minimal, I bow down. But my lord, I am again, my lord, at the cost of repetition, that on these facts, which are admitted, and the defense is twofold. Defense is fraud on underlessee and defense is my city civil court suit. Now, my lord, city court suit is a suit for declaration. My lord, kindly have a look at section 34 of the specific relief. Let us even treat that as a possible defense.
Just address us again on this. They have claimed a relief of declaration of a tenancy. What averments have they made in support of such relief?
Identical averments as made in the written statement. Kindly have a look at the plaint, apropos the question, 216. 213 at 216.
Yes, the plaint is very verbose, very prolix, very...
Well, I'll only show the relevant portions. Well, the plaint proceeds on the same factual background that Malik's original owner, there is a head lease for 50 years, which expires in 2015. During subsistence of head lease, defendant number 1 acquires a lease in 89, which is to continue to 2015. And well, defendant number 1 lease comes to an end in 2015. Defendant numbers 2 to 5, who are defendant numbers 3 to 7, Mellard in the city court suit, they
8 to 11.
8 to 11 in the city court suit, Mellard, they get a sub lease in their favor, and they claim their rights through that 8 to 11. And so they say that they have surrendered because D1 has surrendered, and they say that I have a privity direct with the plaintiff. I do not know who to pay. Since 2 to 5 is no longer claiming, I am to pay either the plaintiff or defendant 1. This is the case of the city court suit. This is the case, my lord. Lordship will not find, my lord. I bow down, my lord. One question fell from your lordship. even if there would have been an averment that I am claiming an independent right, I can understand. But that too, my lord, this is coming by, this is a subsequent suit. I again say that. And the status quo is only with regard to nature and character of possession, possessory right, because they are cases of settled possession.
So today, nothing stops, you would say, stops from this suit being decreed after trial.
Correct.
If that be so, why not Order 12, Rule 6 if it otherwise applies?
First question is, well, there are two tests. Uttam Singh Dugal makes the test on a very high pedestal. That I have to make out a case that taking the defense as it is impossible for the defendant to succeed.
Impossible.
Impossible. Iota of possibility. And my lord, I am placing my case. I had made this submission also before the Honorable First Court that I place this case this high, that taking the defense as it is impossible for the defendant to succeed because of, my lord, the admitted facts which are summarized by the learned judge, my lord, in internal page 13 and 14. And these admissions are summarized, my lord, on the basis of their admissions. There is no dispute with regard to the fact.
So if it is impossible for them to succeed in this suit, pendency of the city court is irrelevant.
My lord, irrelevant. And my lord, even if lordship takes, my lord, the plaint, my lord, the demerer as a demerer to be true and correct, then also, my lord, it is not, my lord, basic ingredient of section 34 is you have to have a legal character. My lord, section 34 reads, my lord, lordship knows, any person entitled, I'm reading, my lord, section 34 of the Specific Relief Act. Firstly, it's a discretionary relief, a declaratory relief. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make such. So first thing, my lord, so far as legal character is concerned, let us assume whatever they have pleaded is correct. Where is the legal character?
These days, to find real character is difficult.
No, my lord, for individuals, character less possible, but for legal proposition, my lord, you will have some character or other. It is not, my lord, absent totally. Now, my lord, now kindly come to, my lord, paragraph, internal page 20. In view of the above, this court finds that the defendants 13 and 14 have raised triable issue with regard to sublease entered by defendant numbers 2 to 5 with defendant 13 and 14. But how is their sublease a triable issue in my suit?
Yes.
And have accepted rent of premises from defendants 13 and 14, and the defendants have specifically pleaded about alleged fraud and collusion, and have also filed their respective suit for declaration of tenancy right. Fraud I have already submitted. 115 doesn't apply once you admit that the main lease has expired. Well, that being the position, my lord, I respectfully submit that order should be set aside and, my lord, relief should be granted in terms of prayers E and G at page 15, my lord, of my main application. E and G. Those are my submissions. Well, this Uttam Singh Dugal has been subsequently followed by Supreme Court, and we have that. I am not reiterating. The principle is okay. Just for the record, we had also served the defendant number 1 since prayer E is there, but when they did not appear before the first court also, and neither they are appearing here. The affidavit of service is on record.
Yes, but this is terms of settlement.
Yes. There is a terms of settlement, my lord. Prayer E was also not allowed because of the defense, fraud on underless or whatever, my lord.
Mr. Chaudhary has
shown most of the documents that I intended to show, but just a few things from the application, my lord. Firstly, from the application for judgment upon admission, my lord.
You are defendants 13 and 14.
I'm
You are
appearing for 13, my lord. Mr. Banerjee is appearing for.
My lord, I appear for defendant number 14. I'm sorry, my lord. Apologies for appearing online. It is not there.
your respondent number 13.
I hope not so unlucky, but
Yes.
my lord, kindly come to the application, my lord. Which is at page 1 of volume 1. My lord, kindly see the prayers.
I'll just take my lord's.
Yes.
So far as I am concerned, my lord, the two prayers that are of relevance are prayers F and G at page number 15, my lord. Prayer F at page 15. A judgment and decree upon admission be passed against defendant numbers 13 and 14, declaring that the said defendants are trespassers and none of them have any right to remain in possession or occupation of the suit premises or any part thereof in terms of relief A of the plaint. And judgment and decree upon admission be passed against defendant numbers such and such, including 13, for khas possession of Schedule B of the suit property upon eviction of the said defendants therefrom in terms of relief B of the plaint. Now, my lord, what are the averments made in support of the contention that these two things can be given upon admission, my lord? My lord kindly comes to it's a composite application, my lord, has a lot of prayers. The relevant paragraphs, my lord, the averments start at paragraph 12, my lord, at page 11. Page 11, my lord, paragraph 12. For the purpose of judgment upon admission, my lord, these are the averments meant. In the meantime, the petitioner has entered into a terms of settlement with the defendant number 1, whereby and whereunder the said defendant number 1 has admitted and acknowledged that the lease in favor of defendant number 1 has expired by efflux of time on 30th September 2015. The defendant number 1 has since accepted the petitioner as the rightful lessee and has also accepted the right of the petitioner to collect or recover occupational charges from all the unauthorized occupants occupying various portions of the 10th floor of premises number such and such. Copy of terms of settlement annexed. Next para 13. In view of the above, the petitioner submits that a decree be passed as against the defendant number 1 in terms of the terms of settlement. 14. The defendant number 2 to 5 in the pleadings filed in the above suit have inter alia admitted that, so the admission is on the part of the defendant numbers 2 to 5, that they had entered into an indenture on 18th August 1989 with the defendant number 1, whereby the defendant number 1 as a sublessor had created sublease of the entirety of the 10th floor of the rear building at premises number such and such in favor of the defendant numbers 2 to 5. It has also been admitted by the defendant numbers 2 to 5 that the lease in favor of the defendant number 1 has expired on 30th September 2015. Such admission has been made on behalf of the defendant numbers 2 to 5 in an affidavit affirmed by Rajendra Kumar Shroff, being the defendant number 2 in GA number such and such made in the above suit. Para 15, in view of the stand of the defendant numbers 2 to 5 as admitted in the pleading above, it is impossible for the said defendant numbers 2 to 5 to succeed in the suit, as the purported right of the defendant numbers 2 to 5 in the suit property was that of a sublessee under the defendant number 1. In view of the admitted position that the lease in favor of defendant number 1 has expired in 2015, as also admitted by the defendant number 1, the plaintiff is entitled to claim against the defendant numbers 2 to 5 in terms of release A and B of the plaint. The plaintiff is entitled to such release as it is now impossible for defendant numbers 2 to 5 to succeed. Now coming to 13, inasmuch as the defendant numbers 11, 13, 14, 15 and 18 were all claiming purported rights from the defendant number 2 to 5, in view of the admission as above, it is impossible for the said defendants to also succeed in the suit. Consequently, the petitioner is also entitled to claim a decree against the said defendant numbers 11, 13, 14, 15 and 18 in terms of release A and B of the plaintiff. So, my lord, the admission that is relied on by the petitioner, my lord, is completely a so-called admission on behalf made by the defendant numbers 2 to 5. Now, whether that admission, because my lord has seen all the judgments that have been relied on, is a judgment, it's an admission that binds the party who makes such admission. Whether that would come upon me, my lord, whether that would bind me for the sake of judgment upon admission, my lord, that is the first point. Apart from this, my lord, then, my lord, they state, the petitioner states that in view of the facts above, there are no tribal issues in the suit, and in view of the fact that it would be impossible for the contesting defendants to succeed in the suit, the petitioner is entitled to judgment upon admission under the provisions of Order 12. So, my lord, there is not a single case in the application that I have made any admission. No admission has been made by me or the respondent number 14, my lord, saying that we are not entitled to possession of the property. Now, my lord, Mr. Chaudhary has already placed the affidavit that was filed by the respondent numbers 2 to 5, my lord. The admissions that they were that are contained, the so-called admissions that are contained therein, that there is an agreement and that lease agreement has expired in 2015. That is all. So my first submission, there is no admission made by the respondent number 13 or the respondent number 14 as regards their liability to be evicted from the suit premises or the fact that they have no right, title or interest in respect of the suit property in any manner. On the other hand, my lord has seen we have already filed suit. Now, there was one contention that this is a prior suit, my lord, and that my suit is a later suit. That is incorrect. My suit was filed at a point of time when I was not made a party to this particular suit. This suit originally was filed only against the defendant number 1. The sub lessees and the sub lessees, they were all made a party to the suit later, much after I obtained that order of status quo against the petitioner. My lord, I'll just serially indicate. My lord, the first lease in favor of the defendant number 1, respondent number 1, my lord, was for 50 years from 1965. Now, the lease was still subsisting, is supposed to expire in 2015. In 2001, while the lease was still subsisting, the defendant number 7 to 9B, that is the Maliks, granted the second lease in favor of the present petitioner, my lord, on 31st of March 2001. In my plaint, my lord, I will place, there is a contention, specific contention that during the subsistence of the earlier lease, the second lease has been granted without delivery or possession. Whether that can be done, the consent of concurrent leases, my lord, that is all there in my plaint. Now, my lord, this defendant number 1 granted a sublease in favor of the Shroffs, who inducted me by an agreement dated 1st of April 2004. My lord has rightly stated that agreement was only for a period of 3 years. My lord, however, it is an admitted fact. I have been continuing in possession thereafter by payment of rent, which has been accepted by the Shroffs at all material times till January 2016, which is after the so-called expiry of the lease. Now, my lord, the rent lastly paid by me, these are commercial properties. I last paid rent of 6,361. I have claimed that this is covered by the West Bengal Premises Tenancy Act, my lord. I am entitled to protection.
You claimed where in your written statement? In a written statement, there is no such claim, defense.
My lord, that's it. So that is the case that I have set up. So, my lord, whether for the purpose of a judgment of an judgment upon admission, whether whatever I have stated, this my lord, reading something in isolation, I have stated some facts. That facts will be.
Query: have you taken this point in your WS or have you not?
My lord, I will just go through. My lord, I have definitely stated what is the rent that I was paying. So.
Material. Yes.
My lord, I have what I definitely have stated is the amount of rent that I was paying. So, for the purpose of my lord, that material fact has definitely been stated there. My lord, I'll just find out where in the WS. I'll point it out. Now, my lord, initially the Shroffs, the first suit in respect of this property, the crisscross of litigations. The first suit was filed by the Shroffs against the present petitioner, my lord. They took the point, they asked for cancellation of the deed of the present petitioner. However, during pendency of the suit, the Shroffs went ahead and surrendered. Whether Shroffs could have surrendered, my lord, in favor of the present.
When did they surrender?
My lord. My lord, can you? Stop को भी surrender कर Stop, stop.
Can I indicate the date?
On 4th June 2016, ma'am.
On 4th June?
June 2016.
And when did the 50 years period expire?
This is
29 September
2015.
15. After that expiry, what did the Shroff surrender, Ms. Shah?
The
What
Shroff
did they surrender?
surrendered their whatever portions that they were in possession of at that point of time, my lord, they surrendered and they left.
You very well understand what we are saying. Carry on, carry on.
My lord, however, the thing is the surrender, the Shroffs had themselves pleaded that the petitioner's deed was liable to be cancelled, my lord. They had fraudulently surrendered in favor of the petitioners. The line, the chain, my
From where did you get that date? That date is surrender date?
You know, that would be from the records of the city court, but that is pleaded, my lord, in my affidavit in opposition. Page 159, my lord, my affidavit in opposition.
All right.
Paragraph 8M.
Very well.
So, my lord, the Maliks had given the lease in favor of Orient and Orient to the Shroffs. Whether Shroffs could have surrendered in favor of a third party, because they were third parties in relation to the premises. If they had to surrender, whether they had to surrender to the original owner or they could have surrendered to a third party, my lord. All this, according to me, these are all tribal issues. This couldn't have been. Now, my lord, during so the first suit was filed by the Shroffs. The suit is pending. Then Orient goes ahead. Orient is the original, the first lessee. Orient goes ahead, files a suit against the petitioner, impledes me, There are cross injunctions in the said suit on me also. Then the petitioner comes ahead, files this present suit, my lord, before this court. I am not made a party. I see that there are crisscross of litigations in the property. My rights are being impinged upon. I file a suit for declaration of my tenancy rights. I am not in a position to say on that day who is the correct tenant. So my lord has already seen my prayer. It's for a declaration of tenancy rights qua the lawful lessee of the premises. So I'm claiming a privity with either the with either Orient or the present petitioner, whoever is the lawful owner of the premises. I am ready to pay rent because my protection, because I am otherwise protected under the Rent Control Act, and I pray that whoever is a lawful lessee, my lord, under the original owners, I may be permitted to give rent to that person. So there is an order of status quo regarding the nature, character, and possession of the suit. After this is done, my lord, they come and implead me in the present. So far as I am concerned, this suit has started after the city court suit has been filed by me. In this present suit, my lord, I am impleaded. I am also restrained from encumbering the
Decree against the shops would have been bound.
My lord, I'm also restrained from encumbering the suit property. Now, my lord.
Tell us one thing. We are trying to learn. Assume that they did not implead you and went ahead with the trial of the suit.
They could have gone. They could have obtained a decree that would have been
Binding on you. Binding on you.
The right to apply under Order 21, Rule 101. If I could have shown anything, that would be there.
Even in your absence, a decree could have been passed.
Yes. I'm not saying, my lord, that the city court would stand in the way of passing the decree.
Right.
My submission is whether what is stated herein, what has transpired from the materials as regards my pleadings or documents that I have brought forth, that can be counted as an admission on my part to decree this suit against me. This is not an application for summary judgment. This is an application for a decree for admission, my lord.
All you need to admit, which you have admitted in your written statement, is that the head lease was from the Malliks to Orient, then from Orient to the Shroffs. The head lease expired in September 2015, and that is enough.
And my lord, I have also stated that there is a fraudulent surrender. My lord.
Surrender of what? That's what we asked.
Surrender, my lord, by them.
Where does 115 come in? Surrender or forfeiture has to be of an existing lease.
My lord. So whether 115 comes in or not, my lord, whether that can be decided here. These are points I have taken. This have to go into trial.
Sure.
My lord kindly comes to, so I have filed the suit, my lord, there's an order of status quo. My lord kindly says this. In that suit, my lord, the plaintiff files a terms of settlement. In my suit, I am not a party to the terms of settlement.
D1 and D2.
D1, plaintiff and D1.
In your suit, plaintiff is
D1
D1.
and D2. They go ahead and files the terms of settlement. My lord kindly sees that terms of settlement once.
That is different from the one which is
Slightly different. Slightly different. They have made a series of terms of settlement. They're going ahead filing it in different courts.
That's favorite hobby.
Favorite hobby. My lord, the rest of the parties to the suit are not parties to the settlement. So I do not know how Order 23, Rule 1 and 2 are. But then in my suit, they have filed a terms of settlement where I am not a party. But my lord kindly sees that terms of settlement.
That has been taken on record by the court.
That is, they have filed it. That has not yet been accepted.
Not accepted.
No, but my lord, what turns on that? My lord, I'll kindly see. My lord kindly comes to page 279 of volume 2. It starts at, my lord, page 276. And let's see, this is my suit, CTI Logistics. versus Awam, Orient, D1 and D2. Then the Maliks are there, the Shroffs are there. None of these people are parties to this terms of settlement. However, it is filed. Now, my lord, kindly see. The terms start, my lord, at page 279. Now, the defendant number 1, that is our marketing LLP, and defendant number 2, that is Orient Beverages, jointly files its terms of settlement to bring on record the following facts.
It's the same, Nisha. It's the same.
My lord, kindly see. What I want to place is at page 280.
Yes.
After 2 lines from the top. The defendant number 2 states that it has no right or interest over 50 Chaurangi Road, rear block, such and such. Defendant number 1 is entitled to receive rent occupation charges from CTI Logistics, that is me. The defendant number 2 accepts the same. So in my suit, they are filing.
Ignore this. Ignore this.
My lord, that is.
This.
So according to them, according to the petitioner,
This is in effect the same settlement they have stated which they have filed here.
They say that they are entitled to receive rent from me. The petitioner says that they are entitled to receive rent from me. What do they accept me as, my lord? That is the question. If the petitioner says that the Orient has stated that they have no right or interest over the property. Orient has stated that the petitioner is entitled to receive rent from me. Petitioner has accepted that it is entitled to receive rent
Where
from
does the petitioner accept?
the defendant number 2 accepts the same.
That is not the petitioner.
Defendant number.
Defendant number 1 is the petitioner.
The petitioner, sorry, my lord. Then, my lord, defendant number 1 states that he is entitled to receive rent and occupational charges.
Where does the defendant number 1 states?
That is
Defendant number 2 states.
280.
Defendant number 2 states.
The defendant number 2 states that it has no right or interest over 50 Chaurangi.
And it's
the defendant number 1 is entitled to receive.
Who says so? The defendant number 2 says so.
And my lord, is signed by the advocates for both the defendant numbers 1 and 2.
Defendant number 2 says so. You cannot.
So defendant number 1 accepts that it is entitled to receive rent and charges from me. Defendant number 1 is the only party apart from the defendant number 2 in this terms of settlement. It's not between me. I am not a party. Nobody else is a party there too. It's between them. They have accepted that they are entitled to receive rent from me. This is after the suit has been filed. So now my lord goes back to the declaration that I had prayed for in my suit.
Yes.
If my lord comes to the plaint, my lord, that I had filed. Plaintiff.
Just to clarify, I don't intend to interject, but by amendment also when we introduced defendant numbers 30 and 14, that is prior in point of time to their suit. It's in August 2018 and they filed the suit in October 2018.
Reply. We will get confused.
Yes. So that your lordship is not.
And note this, what your friend just argued.
Now, my lord kindly comes to my plaint at page 213. Today, my lord, all that I'm trying to show is There is no situation by which whatever I have stated can be construed to be a judgment, to be an admission for the purpose of passing a judgment on it. We can go into trial, whether I have a good case in trial or a bad case in trial, my lord, that's a different thing. But there are tribal issues that I have raised, my lord.
This is a suit, so it can be a suitcase.
Very heavy suitcase to take it
Follow
to
it,
trial,
they can
my
be
lord.
sent. Follow suitcase aspect, they can be sent packing.
There was this story by Jerome K. Jerome in our class 8 or 9, I think. The plane starts at page 213. At page 214, my lord. I've stated the first portions I will not bother my lords with. There's a lease of 50 years in paragraph 4 I have stated. Para 4, my lord. By a registered deed of lease dated 29 September 1965, the predecessors in interest of different numbers 3 to 7, being the then trustees to the estate of Raja Rajendra Malik Bahadur, demise the land and building at such and such in favor of Alapi for a period of 50 years commencing from 29 September 1965. Under the said deed of lease, the said Alapi Finance was given the right to construct new buildings on the said property and to induct subtenants. Subsequently, Alapi constructed buildings in the said premises, which included inter alia the building where the suit property is situated. Then merger, I'm skipping over. Para 8, the defendant numbers 8 to 11 inducted the plaintiff as a sublessee in respect of the suit property, more fully and particularly described in the schedule. Sublessees in respect of the plaintiff was created with the express knowledge and consent of the defendant numbers 3 to 7. Now, my lord, the defendant numbers 3 to 7, my lord, they are the Maliks. I say that with their consent that has been done. Whether Maliks, they are the owners of the premises, my lord. Whether the surrender so in favor of Maliks was the right, it should have been the right pathway for the Shroffs to adopt, or they could have surrendered in favor of the petitioner. My lord, these are all tribal issues. The plaintiff has been at all material times in settled, interrupted and peaceful possession of the suit property. Plaintiff has been making due payment of rent to the defendant numbers 8 to 11 upon issuance of money receipts, acknowledging receipt of such rent. Now, my lord, I'll skip over the unnecessary parts. My lord, my case is one of continued settled occupation. Now, in paragraph 14, my lord, I've stated that even during the continuation of the lease dated 29 September 1965, the first lease was still continuing. The defendant numbers 3 to 7, this is at paragraph 14, executed a further deed of lease dated 31st March 2001 in respect of the said same property in favor of defendant number 1 in respect of inter alia the suit property which was purportedly to commence on and from 1st October 2015. Such deed of lease was executed without delivery of possession of the demised premises thereunder, containing inter alia the suit property in favor of the defendant number 1, which continued to remain under the possession of the plaintiff. So, my lord, I've tried to run a case here of concurrent lease, whether that could have been permissible, my lord, where when the earlier lease is still subsisting, another lease without delivery of possession in favor of the second lessee. Now, my lord, I've after that all the suit, my lord, whatever has happened in the suit, they have been said. I'm not going through that. Now, my lord, kindly see in para 19, my lord. This is a case of fraudulent surrender. My lord says that it is not covered by 115, but whether it does so or not, my lord, at this stage, whether that can be decided, my lord, that's the question. Even during the pendency of the suit, being title suit number 1405 of 2015, this is a suit filed by the Shroffs. On or about 4th June 2016, the defendant numbers 8 to 11 have fraudulently surrendered their right and interest in respect of their leasehold interest and handed over physical possession of an area at measuring 885 square feet, which was allegedly in the exclusive physical possession in favor of the defendant number 1. My lord, I've stated the material facts that I was required to. Based on this, I can raise the issues of fraudulent surrender. I can raise the issue of whether the plaintiff was the right person to have taken that surrender, my lord, from the Shroffs. Then, my lord, the other, again, the suit particulars are given. Now, my lord, in para 22, I have stated I have all licenses and all. I'm running a business of transport and logistics therefrom.
Correct.
I have stated that both the
Mishra, is that order of the court, which court is not mentioned, High Court, which permitted execution of the 2001 lease in favor of the present plaintiff, is it on record?
It's not.
that is not on record, my lord.
No, my lord, it's not on.
Anyway, this is unlikely to conclude today, so bring a copy of that on the next date.
Sir, I do not have it, but
You won't have it. They should be having it.
because all that I have stated and all that I am aware of is this second lease had been executed. Whether that was pursuant to court order or not, my lord, that would be. My lord, then kindly comes to paragraph 24 at page 220. Reading from the plaint. Now, this is the case that I'm trying to run, my lord, whether in the face of this existing on record, a judgment upon admission can be given against me. Para 24 onwards. By reason of the aforesaid acrimony between the defendant numbers 1 and 2, resulting from the grant of a subsequent lease in favor of the defendant number 1 by the defendant numbers 3 to 7, the surrender of leasehold interest by the defendant numbers 8 to 11 in favor of defendant number 1, and the order dated 12th April 2017 having been obtained by the defendant number 2, a cloud has now been cast on the right and interest of the plaintiff in respect of the suit property. Well, that doesn't mean I don't have any right. I'm saying protect my right. This isn't for that purpose. While the defendant number 2 has admitted in the plaint filed by it entitled suit number 456 that the plaintiff is in possession of an area at measuring 742 square feet in the building. The same has also been admitted by the defendant number 1 in his plaint in CS 85. The fact of khas possession and occupation of the plaintiff as a tenant in respect of the suit property thus stands admitted by both the defendant numbers 1 and 2. The plaintiff has been at all material times a sublessee under the defendant numbers 8 to 11 in respect of the suit property. The surrender of their leasehold interest by the defendant numbers 8 to 11 in favor of the defendant number 1, even during the pendency of title suit number 1405 of 2015, cannot and does not prejudicially affect the right of the plaintiff in respect of the suit property. The plaintiff is, upon such surrender, entitled to direct privity with the true lessee under the defendant numbers 3 to 7, be it the defendant number 1 or the defendant number 2.
This is under which law? No, we are trying to learn.
My lord, my lord, there is a surrender. According to me, it is a fraudulent surrender. Whether I succeed or not, my lord, that is a different case. But the surrender has admittedly been made in favor of a third party, my lord, not the original owner of the premises, nor anybody in the chain of the line by which Shroffs got their interest. It was given to another third party who was a complete outsider in respect of the premises as on that date. So, my lord, my lord, all wisdom. My lord, so my position as a tenant, my lord, stands settled today. So whether
And settled.
my lord, I'm in settled possession, my lord.
Settled possession, yes.
Possession. So My lord, that's why I'm claiming that whoever is the rightful tenant, my lord, both of you admit in your respective plans, them and Orient, they have always admitted that I'm there in their respective plans. They have filed suits against me. So protect my possession. That was all that I'm trying to say. And my lord, whoever I'm protected under the Rent Control Act, so whoever I have to pay rent to, I'm ready to do that. I'm sitting with the money, I'll pay. That was my contention in the plaint, my lord, because I didn't know whom to pay to. Now, the plaintiff is upon such surrender entitled to direct privity with the true lessee under the defendant numbers 3 to 7, be it the defendant number 1 or the defendant number 2, upon the adjudication of their respective rights in their pending suits. The right and interest of the plaintiff, along with rights of use of common spaces, testamentary rights, and other rights appertaining to his tenancy in the suit property, is not affected in any manner. So, my lord, now in my suit, they have said that the petitioner is the one who is entitled to receive rent from me by filing the terms of settlement. Para 26, the plaintiff cannot be ousted, nor can the possession of the plaintiff in respect of the suit property be disturbed or interfered with in any manner whatsoever by either the defendant number 1 or the defendant number 2 without due process of law. Then my lord has stated certain incidents that took place, and then my lord kindly comes to paragraph 31. Premises number 50, Jawaharlal Nehru Road, is embroiled in a series of litigations, as has already been stated herein above. The plaintiff, being a bona fide sublessee in possession of the suit property, is entitled to peaceful possession and occupation thereof, including the right to use the common facilities such and such. The plaintiff is also entitled to make due payment of rent in respect of the suit properties to the rightful lessee under the defendant numbers 3 to 7 upon adjudication thereof in the pending litigation. However, the defendant number 1 is illegally attempting to invade my right, my lord. Then I've tried to amicably settle, and then I have claimed declaration. My lord kindly comes to my prayers at page 224.
We have seen the prayers. Just point out in your plaint, where is the pleading relating to your monthly tenancy covered by the Rent Act?
My lord, I do not find it here, but what I do find is at page 229, my lord, the list of documents that shows all the rent bills have been disclosed, my lord.
That's enough.
That is, my lord, the amount, my lord, is 6361, my lord.
Not a single line that you are covered by the Rent Act.
No, my lord, that is them. And my lord, from the W is filed in this suit, my lord.
So henceforth, just list of bunch of documents may be filed. Print is not necessary.
All that I'm trying to say, my lord, that is the material fact, my lord, is there before the court, my
You
lord.
are running a case of being tenancy being covered by the 1997 Act. Not a single sentence regarding that in your plaint.
My lord, not in the plaint, but my lord, from the rent receipts, my lord, definitely I would be able to show. My lord, in my W is filed in this suit, my lord. I have stated, my lord, that is at page 599 of volume 5.
What is it? What have you stated?
My lord, the answering defendant is a subtenant in respect of all that 2 office spaces measuring about 492 square feet carpet area and 250 square feet super built up area respectively situated in the suit property, along with 1 car parking space on the ground floor and the right to use the such and such and in common with other occupiers for rent of rupees 6361 per month.
Very well.
My lord, if my rent bills are there, my rental amount has been, my lord, placed before the court, my lord, that's
So you are claiming to be a monthly tenant under the Shroffs.
my lord.
So if the Shroffs have any right, title or interest, you may be protected.
My lord, if the Shroffs have surrendered in favor of a third party, my lord, the Shroffs have not surrendered in favor of the original owner of the premises. They have gone and surrendered the premises in favor of a third party. Now, this third party and the original lessee, my lord, they are embroiled in litigation, my lord. I am there in the premises. I'm trying to protect my possession, my lord. I file a suit. I seek declaration. Whoever is the rightful lessee, my lord, I'm ready to pay to protect my possession, my lord. Now, in that suit, they file a terms of settlement. Petitioner says he is entitled to all the rents from me. My lord, in these circumstances, my lord, what admission, my lord, whether the admission is sufficient for the purpose of passing a judgment of this, because my lord, I would be non-suited. I would not be able to file an appeal. Therefore.
Precisely the object of Order 12, Rule 6.
My lord, whether that high this case can be
That
placed
we'll
this
have to
high.
decide. That we will have to
Because
decide.
First point that I was saying, that this admission has to be made by the person who is trying to be bound by that admission, not anybody else.
We'll decide that whether it can be said that you have made the admission or not. If we find that you have, then what is the consequence? Mr. Chaudhary has put his client's case very high, and no, consciously so. And we'll have to see whether that is maintainable, whether that is acceptable. That is all we have to see. If we find any doubt, anything that we feel should go to trial, anything that remains for trial, then we may not interfere with the order under appeal. But if we find, according to the language of Duggal, impossible for you to succeed,
But
then
even Duggal, my lord, says person making that admission. Everywhere, it cannot be an admission by the Shroffs. I have, whatever my lord says, that I have admitted certain facts.
Facts, that is always necessary.
Whether in view of the, because my lord, my admissions, so-called admissions, they have to be read as a whole. One cannot be segregated, my lord. I have stated that there is a fraudulent surrender. I have stated that this surrender could not have been made in favor of the petitioners. I have stated that I have stated facts from where I can show I'm protected under the Rent Control Act. These things are there on record. Whether all this can be bypassed, and because I have said that 2015 lease has expired, whether I'm entirely out of the picture, my lord, that is. Think to short Pranesh.
You know, we need the church.
My lord, in the pleadings, in the application for judgment upon admission, my lord has seen the contention is that the Shroffs have admitted that in 2015 the lease has expired. From my WS and from my WO, it has been shown that I have stated that in 2015 it has expired. My case is whether, as I stated earlier, that this can be read in isolation, and whether I have not brought on record any travel issue. That, my lord.
Yes, sorry.
Then, my lord, the Maliks, my lord, who are the owners of the property, my lord, they have not come. The lease is executed between the Maliks and the present petitioner. The court order is not here. The lease is not here. Whether that entitles them to file a suit. They're a third party. Whether that entitles them to file a suit for my eviction from the premises. That is, my lord, a tribal issue.
Yes.
In the terms of settlement, my lord, that they have filed, though that has not yet been accepted by the court, they have said that the petitioner is entitled to receive.
That we have noted, Miss. Yeah.
Whether they have to file a suit in terms of the Premises Tenancy Act for my possession. Look, these all are issues that are there. My lord, they have relied upon the judgment of Uttam Singh Duggal. My lord, before that, I'll just place a few judgments that I had.
Yeah, we are not rushing you. How long you think it'll take? Can you finish today? If not, we'll give you some time tomorrow.
Well, but
We'll give you time tomorrow. Both of you, please come back tomorrow and finish off, because again, Friday is probably now declared to be a holiday. So
That is news to me.
so tomorrow, after tomorrow,
I
when
have
again
finished after my learned friend finishes.
is one particular point we have pointed out to him.
Yes, I'll reply.
So tomorrow, when will you come back? No, you complete today. I mean, you carry on today.
my lord,
कल के तो appellate side ना? हाँ?
তা কি হলো ট্রাভেল ইস্যুটা কি হচ্ছে
Huh? So tomorrow, if we fix this at 12:45, both of you can complete.
I don't know, Mr. Banerjee. I don't know.
Oh, Mr.
Well,
Ban.
Well,
But-
I'll be there. I'll be there tomorrow. Well, if your lordship is takes up the original side tomorrow in the second half, right, Malad? Tomorrow is appellate side, Malad. Second half, your lordship takes up original side.
After appellate side, that may be second half.
After
maybe-
appellate side, yes. Well, can I request 2:30 if it suits your lordships? Malad?
No, it can't be
2:30,
done.
2 o'clock.
Middle of the day like that can't be done. It's either 3:45.
Yes, Malad. Yes, Malad. Yes, Malad. 3:45.
3:30 fixed আছে. Oh, JSOP. JSOP is
Oh,
fixed.
yes.
No.
Oh.
3 o'clock.
3 o'clock. Grateful.
3 o'clock, but please don't repeat. Miss Shah.
Malaj, I will not repeat, Malaj. What I will do is, Malaj, I'll just get a 3-pager note for your lordships. I'll just hand it up.
Very
That's
good.
it, Malaj.
Do
Malaj,
that.
I'll just hand over the judgments, Malaj, tomorrow. I'll not
Yes.
repeat what Mrs. Shah has.
So you try to make as much progress as possible today. Yes.
My lord, before I go into the judgments, two judgments that my learned senior friend has cited, my lord. Money. And all. Judgment of Lord. My lord will kindly just have a look at Uttam Singh Duggal once. Uttam Singh Duggal. Copy.
কি কতবার দেবে একই তো কেস
Oh, that has already been.
why should she rely on a copy supplied by you?
No, no, I would. Do this. My lord, kindly comes to para 10 onwards.
This is the just strength shifted to 6,000. Which para?
My lord, para 10 onwards. On appeal, the division bench notices, I'll in fact start, my lord, slightly earlier. My lord, kindly comes to para 1 and 2, that those are the facts. This petition is filed against the judgment passed by the High Court of Calcutta, affirming a decree passed by the learned single judge of the High Court for a sum of rupees 1015.5 lakhs on application of the respondent for judgment upon admission as provided under Order 12, Rule 6 of the CPC. Facts leading to the suit are as follows. Transorient Engineering Company Limited subcontracted construction of students' dormitories dining hall for University of Baghdad, Iraq. The respondent numbers 1 to 3 functioned as consortium to finance the said project. Certain disputes having arisen, the petitioner filed suits against the respondent banks that the debits raised are illegal, etc. Indian Overseas Bank filed a suit for recovery of certain sums of money and an application made therein under Chapter 13A of the original side rules of the High Court of Calcutta rejected the same, and the respondents 1 and 3 banks and ECGC were also impleaded by an amendment in the said suit. The respondent number 1 filed a suit for recovery of a certain sum of money with certain other reliefs, and in that suit, application for judgment upon admission was allowed. Appeal thereon being unsuccessful, this petition is filed. The application filed by the first respondent bank for judgment on admission covers only a part of the suit claim. The first respondent bank relied upon balance sheets of the petitioner for the year ending 31st March 1989 with reference to Schedule C, D, and E, minutes of the meeting of the board of directors held on such and such, which notice the discussion at the meeting and issues that could be deemed to have been settled as a result thereof, and later dated such and such, communicating the resolution and minutes of the meeting of the board of directors held on such and such. This would not be relevant. My lord, kindly comes to then paragraph number 11, my lord. Learned counsel for the appellant contended that Order 12, Rule 6 comes under the heading admissions, and a judgment on admission could be given only after due opportunity to the other side to explain the admission, if any, is given. that such admission should have been made only in the course of pleadings, or else the other side will not have an opportunity to explain such admission, that even though the provision reads that the court may at any stage of the suit make such order as it thinks fit, the effect of the admission, if any, can be considered only at the time of trial, that the admission even in pleadings will have to be read along with Order 8 Rule 5(1) CPC, and the court need not necessarily proceed to pass an order or a judgment on the basis of such admission, but call upon the party relying upon such admission to prove its case independently, that during pendency of other suits and the nature of contentions raised in the case, it would not be permissible at all to grant the relief before trial, as has been done in the present case, that the expression admissions made in the course of the pleadings or otherwise will have to be read together, and the expression otherwise will have to be interpreted ejusdem generis. As to the object of Order 12 Rule 6, we need not say anything more than what the legislature itself has said when the said provision came to be amended. In the objects and reasons set out while amending the said rule, it is stated that where a claim is admitted, the court has jurisdiction to enter a judgment for the plaintiff and to pass a decree on an admitted claim. The object of the rule is to enable the party to obtain a speedy judgment, at least to the extent of relief which, according to the admission of the defendant, the plaintiff is entitled. I have to admit that the plaintiff is entitled to this relief. Even Duggal places the bar there. My lord,
Admission of facts is enough. Facts. Look at the last two lines of that paragraph.
My lord, reading it as a whole, my lord, then I have to. We should not, my lord. So the object of the rule is to enable the party to obtain a speedy judgment, at least to the extent of the relief to which, to the admission of the defendant, the plaintiff is entitled. Then definitely it does say that we should not unduly narrow down the meaning of this rule, as the object is to enable a party to obtain speedy judgment where the other party has made a plain admission entitling the former to succeed. It should apply, and also wherever there is a clear admission of facts in the face of which it is impossible for the party making such admission to succeed. Whether, my lord, so all the contentions that I have raised regarding fraudulent surrender, surrender in favor of third party, my independent right, my right to stay, to be protected under the Rent Control Act, whether all of this can be wished away, my lord, in view of my admission as to the fact that 2015 Shroff's, the lease in favor of the first lease had expired, my lord, in favor of Orient. Whether that itself can disentitle me from everything else. So that is the level of admission that we are looking at. My lord, I'll be slightly, the other judgments have not come somehow.
Bring them tomorrow.
My lord, I'll bring them
So
tomorrow.
we will
The
post.
judgment that I'm relying on, my lord, and I'll also make, my lord, as like Mr. Banerjee, a very small note. My lord, I'll bring
Yes,
it.
yes, you'll file a very small, short one. Huh? And when should we post it? 12:45 will be sufficient. 12:45 between the three of you.
I think we requested for a second half, 2 o'clock.
Oh, sorry, 3 o'clock.
Whatever.
3 o'clock.
Whichever,
3 o'clock.
my lord, I
3 o'clock, 3:30 we have fixed another matter.
I'll take 10 minutes. my lord.
Take less, take 8 minutes.
As my lord, please.
Mr. Shobhushaji Chaudhary, Kamalan, Senior Counsel, representing the appellant, concludes his opening submission. Paragraph. Ms. Urpita Shaha, learned advocate, representing the respondent number 13, begins her argument but does not conclude. Paragraph lists this matter once again, Kalke date thou, marked 3 p.m.
No, the affidavit of service we kept.
Affidavit of service filed in court today, we kept it. Goda de diye.